Hello, Lyric Armstrong here, your real estate agent and advocate. I'm going to venture out into some uncharted territory because this is important for all of us to know when it comes to legal matters in general. So, as you know, I'm a licensed certified paralegal. I've been working as such for almost 20 years, 20 some odd years. I don't even know how long. It's been a while. A real estate agent and advocate for different laws and legislation to help improve lives of those within my community. That's like the general short bit. I have been watching because that Karen Reed trial, Massachusetts versus Karen Reed. It is very salacious. It is quite interesting of a trial, and so I have been enjoying and not enjoying quite, especially today, because of how disparaging and biased the lead detective, or whatever they call their lead detective out there in Canton. Proctor, he has been his text messages and the handling of the case, in my opinion, has been quite unjust. And what people don't realize in general public sectors is that unjust behavior towards a defendant is unjust to the community. And this is what I'm addressing you guys on today. Unjust behavior, improper rulings, cavalier to the rights of a defendant and the Constitution that upholds those rights for the defendants, puts things at a higher rate of appeal, turnover, mistrial, and consequently, it spends the money of taxpayers in an unjust manner because of whatever proceedings or whatever investigation is happening. Those dollars are going towards an nefarious activity or something that looks conflicting or improprietarily opposing to justice. So consequently, this is why we have the right to counsel, especially in criminal. I mean, civil, you get yourself messed up in civil, you might have to roll solo. But when it comes to criminal cases, our society is concerned that you have a licensed bar attorney. And if you can't afford one, then we will, with taxpayer dollars, pay for you to have one. Unless you just absolutely deny having counsel at all, you have that right as well. But at the very least, it is the best interest of the community to ensure that once you are found guilty, those efforts were not done in vain, that in fact, the facts do support that ruling and the judgments in your case were fair and appropriate and legal. So when an attorney or a legal-minded person or anybody says young thug should have proper representation, Karen Reed has a dream team defense counsel, and it's appropriate. It's not being liberal, it's being upholders of the Constitution. Because the last thing I personally want to do is watch a trial, especially something like the Karen Reed trial, go on for 22 days and more and counting. We don't even have the defense case up yet, but 22 plus days and counting to turn around and go to appeal, and it's all wrong. So today we're going to look at YSL Young Thug snippets of his case. I am not a proponent of the music. I'm not adverse to the music. I have absolutely no idea what his song is. So I don't know the list of songs. I don't know nothing about the man, other than that there's a case. But what I want us to learn is what matters to the society as a whole. And hopefully this will be information you can take and apply to your life and understand why it matters to have proper representation. Okay, I'm gonna try to make sure I'm doing this in the right order because I have a couple of ones we want to pull up. First, I want to thank, I think this is 11 Alive. Thank you, 11 Alive. Thumbs up to you in your video for providing this particular snippet. This is one of the shorter videos. This is in Georgia, for those who may not know, because I didn't know. I was nowhere near this particular case in my life. It just popped up on my feed because I was in Massachusetts versus Karen Reed land. I was the ghost was one of the ghost jurors, and I saw that we lost a juror today. So don't lose any more jurors because I do not want this trial to have to start over. Okay. So everyone stay healthy and stay in it for the cause. And obviously they're not watching this because they're not supposed to be, right? So don't watch this because we don't want to taint the jury. But for this particular YSL case, it has to do with several RICO indictments. This is a series of very important, very serious charges. And the absolute tomfoolery that is getting ready to happen is astounding. Astounding. Any legal scholar is pulling their hair. Everybody wants to write a brief right now. Everybody wants to get in on this. Look, YouTuber here, getting in on this is not even my forte per se, but when you get certified, you have to take criminal and civil. You don't get to choose when you're taking classes. You got to take them all. It's just when you decide to have a practice, that's when you can determine what you want to focus on. Okay, so right now, this gentleman here with the white hair, lovely haircut, nothing personal against him, is a lead defense attorney of Young Thug. And the things that matter most, this is the prosecutor table here. He's the defense attorney at the podium going before this judge here. She is the court reporter or assistant. All right, so now we have an idea of what we're looking at. Let's see what's going on.
I understand my constitutional obligations. Pursuant to the 6th and 14th Amendments to the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told based upon information and belief that when we arrived at 8:30, 9 o'clock today.
Okay. I know it's early. It's like, is it even 10 seconds in? But this very beginning part of Mr. Steele's statement is extremely important because right now they are in, I believe, Superior Court or criminal court. They're on the base level of court. And what he's saying is, I need to make a record so that if, God forbid, we have to go on appeal, there is a clear record. That translates into a couple of aspects. One, that if his client is found guilty, he will need to appeal based upon whatever he's getting ready to bring to the court's attention, because he feels like this is something nefarious and objectable and not suitable to his client's best interest. Two, that when it comes down to going up on appeal, the appellate courts are only going to have the record. And why I'm upset by that is getting ready to be evident to you. They only have the printout. They only have the transcript. They have to read the book. Who said what? Judge said this. Counselor said that. Case was cited. They get the record. They don't get the 11 Alive YouTube channel, Law and Crime Court TV recording. They don't get the audio recording. They get the record, which is in writing. So this is why I'm mad.
He did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers of honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment.
Okay, a couple of key words. Without waiver. One of the most important statements right there is without defense waiver, meaning didn't waive its rights, didn't say, oh, I don't care about counsel, or I don't care about this particular meeting, didn't waive it. It's a very simple word, but it's very important to the statements that are being made. And what is being described is what is called ex parte, where a meeting occurs with the judge ex a party, without a particular party set. And consequently, ex parte communications with the judge has to be waived by the other side in order for them to occur in this particular instance. And this attorney Steele is saying, we did not waive our right to be present. And none of the team was even alerted to the ex parte, which is, I don't even know how the prosecution could have an ex parte communication with the judge without alerting the team, because one of the very first steps is setting the ex parte hearing and then serving notice. Like, you have to serve notice to set the hearing. It's a step together. You do it at the same time. You call the court clerk and you say, I want to set ex parte with the judge based on this particular matter, and you give notice to the other side. So either they failed to give it to the other side, or no one cared if the other side had it. But that's what he's talking about now.
Then I was told, based on information belief, that
Oh, and Mr.
Adrian
Copeland
Love,
is a witness.
the lawyer for Mr. Copeland and this court, were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying "F you," and then somehow that email was CC'd to me. That never.
Mr. Joe, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find?
So someone said, the judge never even says if it happened or not. He says that his very first statement is, the information you're speaking of is ex parte, EX space PARTE. How do you know this? You weren't in my chambers. You weren't in the room when we had these private ex parte communications. That's a problem. Huge problem, Judge, Your Honor.
Find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you a question.
Okay.
Scuttle, if you look at SCUDDER versus state.
He's trying to make his record.
Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somehow accurate based on what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you, Mr. Adams, meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of the record.
Well,
you meet with me, and all kinds of people meet with me. I'm important. I have meetings. So what? Do you have improper meetings? And more concretely, did you have an improper meeting, this particular occurrence in this trial? That's the subject of the motion, because he's in essence making a motion. He's trying to put things on the record. And what infuriates me most is the judge does a lot of deflecting, cutting him off, not allowing a clear record. And it will show itself in the transcript, poor court reporter. It will show itself in the transcript because there will be breaks and twos and fro's and back and forths. However, substantive communication of this motion by the attorney is going to be lost. Obviously, the appeals court will have enough to deal with, because this is just 2 minutes and 57 seconds.
What I was told was that Mr.
And there's
Copeland
more.
And you haven't answered my question yet.
How did you answer that question?
He doesn't have to.
No, I will not
He
answer.
doesn't have to answer that question. And this is a thing that I have said many a time. Ensure that you have proper representation. Ensure that you have proper representation, because an uninformed attorney would be folding to the judge and be like, yes, Your Honor, your secretary told me, or yes, Your Honor, so-and-so said it. No, that information is not pertinent to the motion, and it's not something that the judge has to know. And you're going to find out why. There's several privileges, but the main privilege that's actually, I think, more conducive, because he lists attorney-client privilege. That communication is between him and his client. But then he goes back and says attorney work product privilege. That is the more applicable privilege to this matter,
that what I say is accurate.
to where he doesn't have to tell him the source. Doesn't matter.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have it.
Now you're threatening him. The judge just threatened another officer of the court for doing his ethical duty in preserving his work product in the effort of defending his clients. Why do I care? Because if you are out there and you are, God forbid, in a circumstance where you have to go before the court and be represented by an attorney, I want you to have an understanding as to what is important to your rights, because constitutionally, you have the right to counsel. Counsel needs to be zealous for their client. They cannot just be giving up information to the court just because they want to know. Inquiring minds want to know a lot of things. Do you have the right to the information? In this particular instance, no, you don't.
Right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point
You don't want to know about your problems. You don't want to know about nothing. How did you find out? Who told you? Who's the snitch? He wants to know who's the snitch in his office, because he wants to reprimand the snitch in his office. But we're dealing with a RICO case, and we got Mr. Copeland coming, and maybe he's going to be the snitch for the case. I don't know. But is that how we do it? We gangster in the courthouse too? No, the courthouse is supposed to be where you have the quorum and order, ethical procedures and evidentiary procedures to zealously represent both sides and come to a truthful and honest conclusion. not an overly
How did
biased
you
one.
come upon this information? Look,
Doesn't matter, not your
reviewed,
business.
the record's going to be available for our appellate court and for whatever reason. But it's disturbing that somehow you
How is the record available? He hasn't even been able to make the record.
in regards to the court's private ex parte conversation with the party. I mean,
a witness who was sworn in Friday. The court's telling, this is what I was told. If it's not true.
First of all, ex parte conversations with the party. That would be worse in my opinion. How are you having a conversation with my client or anybody else's client without attorneys present?
Yes. A witness who was sworn in Friday. The court's telling, this is what I was told. If it's not true, not true. This court handed Mr. Copeland.
It's true. He didn't already told you it's true.
Listen,
tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
or information that you
proprietary.
should not be having.
This is not trademark and copyright court. We're not up here for the U.S. trademark proprietary intellectual property concerns. That's not what you're doing. This is a criminal case. It's not proprietary. This is not judge with judge and, judge consulting another judge on how to operate his courtroom. This is ex parte communication without the waiver or presence of the defense counsel. It is disparaging to the case and it is biased against the defendant. It is unjust to the public and to the community. For if this man is at all found guilty, because right now you're in mistrial land as far as I'm concerned, but if this man is at all found guilty, we have an appealable matter because this judge can't let go of power that really is not his at this juncture.
You have proprietary information or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court,
okay.
Excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton.
Do you ever know? Okay, so the judge is being very, he's not loud. He is cutting him off, so he has some rudeness to his presentation, but as you'll notice, judges do that, and it's not necessarily wrong. It's just rude at times, but it can happen, especially if there's an objection on the floor, then it's most appropriate that they cut you off because the objection has to be handled. But this judge is very he hasn't raised his voice. He's threatened him with some words, but he hasn't jumped up off the bench and given any real physical assaulting kind of body language. But he's a mad bully. He's a bully right now, in my opinion. He is taking the authority of the court and abusing it in disproportionate amounts, in my opinion, because he is the not finder of fact. I don't know if this is a jury case or not, but since he is the finder of fact relative to this motion, because there's no jury here, and he is the administrator of the law at this juncture, and he's a witness to the problem at this juncture. So I'm sorry, I've known people to wear different hats and have many a career in all kinds of different careers, but you don't get to be judge and jury all in one against yourself. You don't get to do it. That's not how it works. There is actual procedure for when you become an issue to the case. But it's interesting that his voice is very okay, you would think he's not doing anything wrong. He's actually being very, very wrong, and he's being a big bully. And the other gentleman, the actual attorney in question, is being zealous, advocate for his client, because he's noting that there is impropriety happening. This is a problem going on within this court, having ex parte conversation with a witness that is supposedly the one who knows that Young Thug or whatever did all the things they say he
said. Actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to.
Which is why you don't have ex parte communications, because witnesses say you coerce them into saying whatever.
How did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir? I'm going to hold you in contempt if you don't tell me who. Tell me who this information.
Another threat.
Well, then answering that question. That's attorney-client privilege information. I have not.
Attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out. I tell you what. I'm going to give you 5 minutes. If you don't tell me, if you don't tell me who it is, I'm going to put you in contempt, because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information?
Now you see this lady. Oh, excuse me, Lord. I was getting rid of this lady here, shaking her head. It is attorney work product privilege, because what this attorney does to find out what's going on in the best interest of the case of his client is the product of his work. So such privilege does actually apply. And this attorney on the prosecutor's team shaking her head vigorously, no, 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 it's not, should be ashamed and outright apologetic to all of the Georgia public that they have wasted taxpayers' dollars and that they have put this case on in such a way that it has all of the makings of a mistrial or being turned over by appeal because they cannot conduct themselves with the proper decorum for which they took an oath to uphold the Constitution and not trample all over the defendant's rights to know and be availed of the different aspects of their case. You don't go ex parte and not get the waiver. And you didn't get the waiver because you probably didn't even notice them because you don't care and you didn't do evidentiary procedures, in my opinion.
Who it is, I'm gonna put you. I'm gonna
But
put
her
you
right here?
in contempt because that is not
Let
attorney.
me shake my head right back.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I am not. You should have told me.
Exactly.
You got 5 minutes.
Well, you should have told him.
This is what I was told.
The prosecutor should have told him. Every last 1, 2, and 3.
Donovan Thomas. Don't take my notes. No.
So I know that. Hold on 1 second. We have a lot of background noise here. I know that there is some, updated information. And I know that the judge is taking a lot of the heat for what has transpired because in that room, the judge is, the one with the most knowledge and should be most astute to what the law is compared to all of the other attorneys. But when you combine the years of knowledge, maybe they should know better. But most certainly, I believe the judge should share the heat with those prosecutors who went forth in an ex parte hearing and did not inform the defense so that they could actually receive a proper waiver. And I swear I can't stress that enough to you because there is no reason. Okay, so this is Law and Crime. Okay, thank you, Law and Crime. We give you a thumbs up for providing the next video. I cannot stress enough to you as to why that is important. First of all, you just want to get it right the first time. You don't want people getting off because you have botched the investigation. You don't want people getting away with murder or RICO cases because you can't follow evidentiary procedure. You don't want people getting away with criminal activity because you don't understand what it means to have an ex parte hearing properly by getting the waiver. And what does that do to you, Georgia? That increases your taxes because your people, your attorneys, your prosecutors, and your judges are costing you extra time and money because this court reporter, she gonna get paid. She gonna clock her hours. And these little prosecutors, they gonna get their check. I don't know who these people are over here, but if there's another, clerk in the room, they gonna get their check, they gonna get their hours so they can sit here and argue. So right now, here comes some more argument. Okay. What's right is right. What the law is what the law is. And we can't, or I'm not going to bring in political elements. But right now, you can probably see a political stage. The prosecuting office and the judge are out of Georgia. And so we kind of know who's the famous DA out of Georgia. I'm not going to name drop. And this young lady here has come up against that DA speaking to nefarious activity or that which looks like conflicting activity nonetheless. Cost us a little time in trying to get cases before the court in a timely fashion because they have to pause and clear indiscretions, right? That's what's happening here. We have to pause the YSL Thug Nelly, I don't know, what's his name? Young Thug. We have to pause Young Thug's case. The RICO case is just supposed to be so important to Georgia because of impropriety and improper actions by the judge and the prosecution. So you want to know why taxes go up? You want to know why things are expensive? It's because people don't do their job in accordance to their will and accordance to the court that they're supposed to, in my opinion.
Mr. Steele, I am going to hold you still hold you in summary criminal contempt.
Summary criminal contempt. Please be clear about what he did.
The judge in Young.
Oh my gosh, now we have somebody else talking. Okay, I don't really want her. I want it. Okay, that's fine. Hold on. This is not the one I want. I mean, thanks, Law and Crime, but I don't need your commentary. My big mouth is enough. Okay, hold on. It's fine. Okay, I'm not gonna get the version I wanted. So this is Law and Crime Sidebar and some of their commentary. I don't necessarily agree or disagree with their commentary because I haven't listened to it. I'm more concerned about what's going on with the court and what is being said.
How did you get this information?
So he's back to
And it is
badgering
not
him,
covered by work product. There's only one way you could have gotten it. So
and he is telling him it's not by work product, attorney work product. So therefore, it's not a privilege that you can assert. Well, you can't make that determination there, sir. You should be recusing yourself and having another judge come in and determine by facts if, in fact, this was as a result of attorney work product.
So I'm going to ask you again.
You can't be the subject and the object at the same time.
And I respect it. And it gives me no joy, but as you know, Georgia Rule Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have.
1.6 and 2.5.
1.6. I know what the rule says, but here's the thing.
Well, I'm just.
I don't believe him. When he gets,
but in order, you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers, parroted to you and others. It is that serious.
Yeah, and that's why I raised it. It is that serious that we should have been there and it shouldn't happen.
Sir, that's a whole separate issue, and that's why.
Not a separate issue. Your issue of who your whistleblowing bird is, who the snitch is your personal issue. That's between you and yours, right? The issue of the court, before the court, is the case, and the defendant's rights have been violated. That's the issue before the court, and you are a witness to that violation. If not a participant, you are a witness.
That's why ex parte conversations are recorded.
Why would it be ex parte?
My private conversation.
What? Been there and it shouldn't happen.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte?
You're acting like it's ex parte under seal. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
You've never asked the Samba court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
He's saying because the state asked me to meet with him ex parte, I did it. So he has the ability to tell everybody else no except for the state. Like, what are you talking about? And the reason why I said I don't believe that he knows the rules is because the rule says the ex parte can be granted if the other party issues a waiver to their right to be present. You cannot issue a waiver for your right to be present if you're not even informed that the meeting is occurring in the first place.
The issue is, how did you get this information?
I understand the issue.
Ooh, you mad? They told on him.
Look at comment 5.
Someone had the nerve to tell on him.
You can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you.
Okay, but see, the privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading wrong, I'm not trying to. It says 1.6 applies not merely to matters.
You do a lot of wrong reading when it comes to some case law in a minute.
All information gained in the professional relationship, whatever its source. So you're asking me to break your order, maybe. You're asking me. I'm not saying you're ordering, but to give you information, and you're saying it's not some substance. But I'm telling you, I can't do that under the bar rules.
All right. Well, I'm going to hold you in contempt.
So, Law and Crime Sidebar did some clipping, and we've obviously done some clipping. We're not going to sit here and spend 2 hours or 3 hours, however long this particular matter took. But what the attorney still stated was, I cannot divulge this information to you, otherwise I'm going to be in trouble with the bar. And as sexy as that might sound to a few people, he ain't talking about margaritas and martinis. He's talking about the bar of the legal bar, Georgia Bar Association. And consequently, he's saying I can lose my license by not protecting my client. And he could, because divulging that information is not in the best interest of his client. And quite frankly, the judge is in such a precarious placement, being, judge and jury and witness to the whole matter, to where he's not impartial. So you need an impartial judge to do the investigation to determine if the work product privilege would apply. Not the judge who is so upset that someone has snitched on him and told something out of his sanctimonious chamber. This is not confessional at the Catholic Church. There are times that things that are happening in chamber can be improper and therefore do not get to be held under lock and key. Case in point illegal meetings or
Got it. 5 o'clock today. We'll
that
see.
which
We'll see
looks
where you are at that stand on
as
that point.
that
Because no, that's not what I.
illegal
That's not
and or
what I
improper.
understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you
Some
can, because I
substance
have an
is
idea
what
how
he
you
wants
got
to
it.
put on the
Well, your
record.
idea
I
may
have an
be
idea how
wrong.
you got it, but
Isn't that funny? The judge does not want the record to be clear that he was communicating improperly with this potential witness who wants to plead the fifth and all these other things that he needs to assert or not assert. He doesn't want to clearly put on the record. Because I said, be careful about the fact of thinking that the judge is just being so kind and he's just trying to find out who told you. No, that's not. He's not trying to just find out who told you just because he wants to know. It's because he has a retaliatory nature. He has done this throughout this case. He has threatened this gentleman to put him in contempt for not telling him who told him the information, while not allowing the attorney to make the record clear and to get his motion and his points on the record in the first place. He has cut him off more times than I have clicked pause. So, okay, yeah, we know you don't want substance of the information because you don't want that on the record. You just want the name or the person who told so that you can go handle that in the back room versus dealing with the record and the proper record of the court.
that's improper. Sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not
Sir,
going to breach that
I don't
confidence.
want to hold you in contempt, but this is that serious.
Judge,
You
I don't
cannot
erase it.
you cannot easdrop and get
Eavesdrop.
information that was not.
That-
Judge, you listen, and listen. I'll do whatever you want.
You cannot
To 5
accuse
o'clock
him
or
of
thereafter. What I'm
eavesdropping.
trying to tell you is, Your Honor, this is so serious to me. We need a hearing. I'm moving for a mistrial. It is my understanding, based upon information belief,
From
that
whom?
part of it.
From whom?
Well,
None
I'd like
of
to
your
get the
business.
substance first, and then we can
Okay,
talk
well,
about it.
then you'll be in custody
I
until
have
then.
nothing to
Because-
do with this.
Because you need to tell me how you got the information. I'm not
Okay.
asking you what was said.
The Zeiss VisuCore 500 combined refraction unit consists of a Zeiss VisuCore 500 refraction.
You've already kind of given
I have nothing to do with weight loss medications and all that advertisement, and I don't endorse anything of that nature. Okay.
us some snippets of what you said. That tells
No.
me that somebody parroted that information to you.
Someone
But you're
snitched,
assuming something because I
parroted,
told you.
they were
Well, then,
bird.
other than
Answer
if
that
you were
under
sitting, unless
attorney-client.
you were sitting in there with a
Like a
recorder
bird.
or Miss Love or Miss Hilton or one of the deputies gave you that information or Miss Weaver.
Okay, so we had Miss Porter, Miss Love, Miss Hilton, one of the deputies. So it was at least one, could have been two, Miss Weaver, Copeland. We got 6 other people in this ex-party communication, and you're leaving out at least one defense attorney. Okay.
Shot you a rough copy of the transcript. There's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well,
She.
let me tell you two
Oh, it's a
things. One,
she.
I don't know how that is a privilege.
Oh, wait a minute. So this this gets interesting. I didn't even see this part. So the judge is asserting that this is the ex-party privilege of prosecutors, and the witness and his attorney, I believe, was in the room to speak with the judge ex-party. That was his privilege to do so. And that the defense attorney seeking knowledge of this ex-party communication is violating these other people's privileges. They're not on trial in this case. The person on trial is Young Thug. Those defendants, or that defendant, they are the ones with the privileges in this case. They are the ones with the rights in this case. It's not a juror. It's not to say, oh, where do you live? What's your blood type? What's your social security number of the juror? This is a witness. You had ex-parte communication with the witness.
Communication. It shouldn't
Well,
have
it's
been.
Without
because she has a
waiver.
client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to.
Wait, what?
It shouldn't have
Well,
been.
it's because she has a client she's supposed to represent.
She has a client she's supposed to represent. What are you talking about, Judge? What are you talking? What do you even mean? What do you mean you've given us 6 names? Who has a client to represent? Because Steele has a client to represent who's actually on trial this very minute. I think the ex-parte communication, as I listened to some of the banter as to what was communicated, it sounds like the witness was hesitant to want to testify and wanted to assert his Fifth Amendment right and his privilege to his Fifth Amendment rights. And the attorneys, whomever the she is, because we got a couple she's on the prosecution, and I believe he had an attorney female at one point during this process, have the right to represent him, this particular witness. Okay, true. But the case that is before the court is against Young Thug by his real name, his government name. And so therefore, the rights that are asserted are his. And what you've done is gone against his constitutional right to waive the privilege of being in the room. And you're mad because the defense attorney found out. But you want to protect somebody else's rights and privileges, but you're not protecting the rights and privileges of the defendant. So therefore, when or if there is a time that he's found guilty, you've given a whole bunch of latitude for him to have a mistrial or to have a conviction overturned.
But anyways, I'm not going to have.
When I got this information,
I'm not going to have any further conversation
Well,
about this. I want to
Isn't
know.
that so kiddish?
the
I'm not
question
going to have
still
any further
remains.
conversation. I'm not
I
going
want
to.
to
You
know
won't tell me what I want to know.
how-
I won't talk to
Who
you.
gave you the information?
I'd like to know what information happened outside of presence. That's really it.
You can go into custody at this point.
Prosecutor Adrian Love,
Okay,
she actually
so
asked that Brian
again, we don't need to know what are these people called? Law and order.
Steele be allowed back in the courtroom for the
Law
rest
and
of the
order
day's
site
proceedings. The judge eventually let him back in, and at the end of the day, discussed the contempt proceedings.
We need to know
So
what they
happened?
think.
Ashley Merchant, who's a very well-known Atlanta defense attorney.
Okay, wait. We just need to get to Ashley. I don't want to hear you tell me about Ashley, but this is Ashley Merchant, and I'm grateful for her presence. I can't listen. A good lawyer is a good lawyer, and I'm grateful for her presence. So she gets on the scene.
He represented Brian Steele during all this, and Merchant and a second attorney, Alex Susser,
Sorry,
argued that
Jess.
if
I just don't
Steele
wanna hear
was
you.
in contempt of court, there needs to be a hearing because there's a difference between civil
right.
contempt and criminal contempt, where Merchant was saying if it's the latter, if it's criminal contempt, you need to hold a hearing for due process purposes.
It's like he's just gonna summarize. That's my job. Doesn't he know that? That's what I'm doing. It's my channel.
Is the criminal contempt? Is it criminal contempt?
Okay, so she's on the scene now. We can finally get to what I need to get to. After sidebar with Jess just took up all of the energy. We're gonna have a great time editing this. Okay, so here's Ashley. She's on.
Contempt that you held him in?
Yes, ma'am.
Okay, and you said you
Judge Glanville
So she
disagreed.
is the
confirms,
criminal contempt.
she confirms charge, and that's very important because the judge, and I don't know if you've actually seen it because this is more choppy than I had hoped for, but the judge it was like charging him with criminal contempt, but he was saying, but you can purge the charge, which is actual civil contempt. So it's like I'm charging you with one aspect of the law, but I'm giving you the penalty of a different aspect of the law, and those you can't do that. Like if it's a criminal contempt, then you have the remedies of XYZ. If it's a civil contempt, then you have the remedies of ABC. They're different. So that's what she gets into. She confirms that he is saying criminal and he's not just misspeaking, even though he does a lot of double talking at this time.
Is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
No, with criminal contempt, I told him what the contempt was, and that was he refused to tell, order the court. If counsel, as you know,
Oh, girl.
if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you.
He's so nice. I asked him several times, please just tell me. Just please just tell me. I asked him several times, please just tell me.
I didn't ask to inquire about
You have
anything
no right
that was said.
to the
I just want to know
information
who
that
it
you're
was.
asking.
Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client.
Okay, they cut
So he is
something.
being placed in a position where he's either going to jail
They cut.
or he's going to commit an offense that will
important
put his license to practice law at risk.
Okay, they cut an important part because she actually has more back and forth with the judge. The reason why the judge is even turned away from her and this other counselor is because she has cited a couple cases where it states that the judge basically is not judge and jury in certain circumstances. And so one of the main cases, it was ex parte, and the judge had an ex parte hearing without one of the parties being present. It went up on appeal, and it was found that they cannot have ex parte hearings unless the defense waives the right to be present. So that Georgia law comes in through case law. And then I think she has a code that she cites that kind of supports that further. So he's looking at this particular law that she has cited. He's taking issue with her relative to the age of the law from 1994, which quite actually is not old at all. Law is old. The law of the land is old. 1700s, 1800s old, right? So the Constitution is old, but to sit around and say that the law in 1994, 1998 is not recent enough to be applicable is absurd. What it means is that there's nothing that has overturned it. There's nothing that has changed it since. And so therefore it's still applicable and it's pertinent to the matter. But he finds a way to say, no, it doesn't. Then the other gentleman that's with her, these individuals are in representation of the first defense attorney, which was Mr. Steele. These individuals have come to the scene because they are a part of the strike force. This is why I say attorneys even know that you don't represent yourself. You have a very astute, as one would assume, relative to his presentation. This particular attorney seems to be astute, Mr. Steele. However, he's astute in criminal defense because he's defending a young thug in this particular trial. And however, he's before this court now being charged with criminal contempt. Well, so he's not going to just represent himself. So learn from this. This is important to note that even astute, well-versed attorneys in a specific point of law still have the gumption and understanding that they need proper representation outside of themselves, because you need the objectivity viewpoint. You need to be able to kind of go and have toe-to-toe moments with the judge. And the judge's demeanor is a little less aggressive compared to where he was a moment ago with Mr. Steele, because now he's before someone new, so the rapport is not tainted in any way. But this is something you may not know. There's actually 25 of these individuals standing outside the courtroom wanting to come in to help their fellow attorney argue and speak with the judge to bring him back to reason, because he has lost his mind at this moment. This is the legal way of losing your mind as a judge. It has to do with, in my opinion, has to do with having the power and not understanding the responsibility that comes with the power. A lot of times people say, oh, you're the president. Yeah, that just means you get blamed for everything. It's more responsibility if you're serious about the role than it really is the accolade. It's the responsibility, not the power. So consequently, this judge has a great deal of responsibility that his emotions have escaped him from and moved him away from, to where he is kind of drunk on his power. And he has made an improper ruling trying to assert two different things. This other gentleman is saying, Your Honor, in representation of the client, which is now the attorney Steele, my client is unable to disclose to you the information that you seek because it is disparaging to his client. So that's the arguments that are being made.
And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client. And he is simply trying to protect that duty of loyalty and duty of confidentiality.
And he should have a hearing because you gave him criminal contempt.
It is very reasonable
but you won't let him have a
and
hearing.
likely that he will be facing a bar complaint that could result in a suspension
if he
or
complies with your ridiculous order.
And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their...
An impartial judge, meaning not you, because you're a witness, judge, Your Honor, to have a demand for respect for your court and for your order and for your word, but yet to disrespect the law in such a way that this judge is doing, I'm surprised he will be employed next year.
I'm not doing that. I'm not doing that. Reason being is because that takes away the whole point of criminal contempt, and that is you do something, the court tells you to do something, order the court, and you don't follow it. I didn't ask him to do anything illegally.
I'm sorry. Having a hearing on a criminal contempt order takes away from the intent? No, it's a part of the whole process. If you charge him criminal contempt, the process is he gets to have a hearing with witnesses and an impartial judge.
Moral and ethical. I just asked him to tell me. I know what the privilege is. The privilege is a conversation. I didn't ask him about that. I wanted to ask him about who, the person, because okay, I'm sorry.
Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
And it didn't end there. No, because Merchant also advised Judge Glanville that
there
were 25 attorneys from the Georgia Association of Criminal Defense Lawyers that were right outside that courtroom that were ready to jump in to represent Mr. Steele.
I just told you all about that.
Judge Glanville said there's no room in that courtroom for all of them.
Which was a lie.
Apparently said, well, what about the jury box?
Here's also, okay. I mean, good on sidebar, they caught it.
This AI tool will take your idea and create a complete book, complete with design, images.
All right, good on sidebar, they caught it. And obviously this case is, in this particular matter, is hot topic because every 5 seconds something is interrupting the stream, whether it's a commercial or the guy, whatever. But yes, the judge said there was not room for the 25 Georgia Bar Association reps and the strike force. Those are two representations that were there. It was around 25 attorneys in total. And I think the two that are next to flanking Mr. Steele are representing one each. Like I think she's representing Georgia Bar and then the other gentlemen were representing the strike force, whatever the case is. The judge says there's no room in the court. They're like, there's a row back here that's open. There's the jury box that's open. And I can't tell you how many times officers of the court will go and sit in the jury box and wait and, pass things back and forth with the clerk. They could be there for a whole nother case, different case than what's going on before the judge at that time. They're handling business or they're just waiting for their case to be called. And there's no room in the gallery because the public is there or all of the defendants are there, like traffic court. Imagine traffic court when everyone's got a ticket and they want to fight it, and then you have maybe the officers who issue the ticket, or you have other attorneys who are sitting in the jury box because there's no other place to sit. This is not unheard of. This judge says in response to that, yes, but we have security concerns, because he makes this implication, in my point of view, that since it's a RICO case and there's a potential bad actors, or that this is some high level criminal activity that's possibly or at least alleged, possibly asserted, at least alleged, that they have to go through an extra layer of security. These are attorneys. They are officers of the court. So what does that mean? They have a license, they have a bar number, they've already been fingerprinted, they've already been vetted. He's like, we haven't vetted them, so they can't count. That's such a false argument.
Hold you in summary criminal contempt pursuant to
No,
OCJ 15
summary criminal. That's what he gets.
3 for your failure to comply with my earlier order today. I'm going to order that you be taken into custody.
Okay, there's really nothing else. I think a sidebar is just going to keep giving us more stuff to look at. Hopefully, the next video will not be so annoying. No, actually, we have a whole lot of people in here that have nothing to do with what I want to talk about. But anyway, back to the point. Like I said, I'm not arguing whether Young Thug is or is not guilty. I have no idea what the facts of the case are. None. I'm not in it. Okay, my name is Bennett. Honey, I ain't in it. But what I do know is the justice that is deserved to whomever. The community at large deserves justice, and it's not being availed to them in this circumstance. Mr. Steele is arrested, unfortunately, but I believe he gets out. I know that the appeals court has done a solid and looked at this very quickly. Law and crime. Okay, I'm gonna give you a thumbs up, law and crime. Please don't start talking, because that's my job, and it makes it hard enough.
Accuse me. You file an affidavit.
Okay, so yeah. Okay, so he put up a motion to recuse him. So even though you can say, obviously he should recuse himself, obviously the judge should know that, he's too vested, and now he's a witness in this particular matter, that there's things that need to happen before the case can go on, because ex-parte communications with the very next witness occurred that could have been coercive. And the reason why that is the case is because the judge represents a great deal of power, just in his presence, in his chamber. Picture in your mind sitting in the judge's chamber. You've already said, I don't want to testify, I'm pleading the fifth. And now, for whatever reason, you're being pulled out of your cell or wherever you are, and you're before the judge, 5 to 6 other people, because he just started naming off people, and court reporter, and all these people are around you. And now we're having a conversation as to why you want to plead the fifth. That can be intimidating. And maybe he's intimidated. Maybe he's not. Maybe he said those things. Maybe he didn't. The judge seems to agree that he did say that he wanted to plead the fifth. The judge seems to have agreed that there was a plea deal offer, that he is a murder in a different case, and he got a plea deal off of that case so that he could come and testify to this case. That's not unheard of, but it should be disclosed, especially to the defense, because it helps them to advocate for their client. So maybe those things were said, maybe those things weren't said, but ex-parte communications have to be waived by the other party. You can't just have it just because you want to. So they put a motion to recuse. This is for the record. He, of course, is not going to recuse himself because he's emboldened. He denies it.
Court will 25.2. The court had an opportunity to read your motion.
He read it.
An opportunity to take a look at it, because this issue comes up a fair bit. Baptiste versus the state. I invite you to take a look at that, and that's in our Court of Appeals, 229 Georgia Appeals 691. Basically,
sorry, guys,
can't file a motion to recuse for ruling that a trial judge makes. Okay, and that's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse ruling. So
every legal mind can argue every side of the coin, right? It's very seldom that you find legal-minded people that agree completely and wholly on an issue, just because you're trained to see it from all angles and to see it flip side over. But he has flipped this coin so tough to where he would not be wrong ever in his life. Like, it's as if he doesn't know appellate courts exist. Like, does he not know that the Supreme Court is a thing? Like, that's what happens. You don't just walk up to the Supreme Court and say, here, I have an issue, fix it. No, you have to go through the trial court. The trial judge has to make a mistake, do wrong, hello, wrong ruling, wrong findings, wrong impropriety, conflict of interest, whatever. Then you appeal to the next court to say, look, judge did wrong, or here's new information, or this evidence was kept out of trial court improperly, whatever your arguments are. But those arguments are based onto how the case transpired in trial court. So to make some assumption that all his orders are proper just because he's the trial judge, and therefore there's no such thing as recusal, and there's no such thing as I've done wrong, I need to back away from this, is absolutely absurd. It's just hubris.
For the reasons set forth in
he has all the
and other
power.
cases, I'm going
He's
to
the
deny your
witness,
motion
he's
to
the
recuse
judge,
in this
he's
case, okay?
the jury, the appellate court, Supreme Court. He has all the
No
power.
living being should ever eat
Oh
processed
my
food
gosh,
for
he has
every
all
single
the
meal of their
power.
life.
He has all the power.
With your characterization,
I don't even know who this judge is.
filed a motion
I mean, this
to result in
attorney.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value. Okay. All right. I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a ruling. And as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever, okay?
Not every ruling, dear sir. It's every ruling that presents conflict, bias, and or disregards the defendant's constitutional rights. What you're doing by the ruling. You didn't rule over an objection. It's a motion for the issue of ex parte hearing without waiver of the defense. With a critical, vital witness. The defendant has the right to confront his accuser. You don't like, not confront like run up on, but he has the right to legally confront his accuser. And a part of that is to know who the witness is, what they're testifying to. There's not supposed to be surprises in court. So, okay, Judge. Well, that sounds like the appellate court has a different thought for
Part
you.
and parcel of it is that's why I'm making my ruling.
And I'm hoping so does Georgia. You need to be relocated. It's time for early retirement.
Judicial, and I don't. You're in your
in my
particular. Opinion. Like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process.
Well,
so I understand what your objection is, or what your statement is in terms of your motion to recuse. I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3.
Well, okay, judges can make orders based on the pleadings. You can do that. And like motion for summary judgment in education is based upon orders on the pleadings. So this is true. However, I haven't heard him yet let the attorney of any attorney make a clear record. He has, under most circumstances that I have heard him in this particular matter, for this particular type of motion that's going forward, he has interrupted the attorney and no record is clear as to what the facts were precisely, what the complete arguments were precisely, and all the case law in support thereof. So the points and authorities are not accompanying the motion. So hopefully these are written motions. I've heard motion that's been, from the floor. I don't know that they've actually done a written filing of the motion. I know they did the written filing of the recusal, but I don't know they did a written filing of the motion that actually got still put in jail for contempt.
Motion to recuse, I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And that if I could just finish.
I'm just saying, I don't have to do nothing. Well, you surely don't have to listen. So, Georgia, your judges don't listen. They don't listen. This judge, he don't have to listen. He doesn't have to listen to the attorneys make arguments. He don't have to listen to the attorneys quote the law. He don't have to listen to nothing because no, he don't. The man hasn't even got his sentence out yet. I barely know it's 25 something. I don't even know what code he was talking about. Probably evidentiary or rule. Probably the rule.
Right now.
No, I don't.
No, we don't. No, we don't.
Your Honor, that under Rule 25.3.
Yeah, Rule 25.
You have to cease acting right now.
No, I don't.
And that if I could just finish, and then I promise.
I can just finish this. I believe you have to cease acting. I believe that under 25(3), you have to look at the timeliness of the motion and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
All he wants him to do is stop talking so he can say, no, I don't. I'm laughing because why not? It's a great day in my neighborhood. But if I was this defendant, I would be absolutely appalled that this is what I'm getting as a judge over my case. And therefore, you too should be appalled because you never know. This might be the type of judge you're getting over your case. Karen Reed, she woke up 5 o'clock in the morning looking for her boyfriend, and now she's charged with murder. And I believe it's intent, right? And then there are those who, they wake up one day and get drunk and do actually cause murder. And I don't know if Karen Reed did or did not, but the case ain't looking too good for the prosecution. In my opinion, that's just my little opinion. But those who do cause murder, you still want a judge that can actually preside over the case in an impartial manner. And this judge is not showing any parts of that because no one can get a sentence out. There's not a law that he wants to listen to, and he ain't got to do nothing the law says because he's the judge and he says so. Oh, this is why you have to vote.
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion. Okay.
Will you grant a certificate of immediate review?
No, sir.
Because
no, sir.
If you grant that certificate, you're always talking about how the appellate court.
No, because if I grant the certificate, it stops the case. Okay.
I don't agree.
And I'm not going to do that.
I don't believe it stops the case.
I'm not going to do that.
And if
you can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it. Okay.
So you can appeal it at the end of the case. We're just gonna go ahead and lock them up. And when we done doing that, you can go ahead and appeal there, baby. See if you can get that overturned. But we have a problem. A key witness is compromised. How are we going to accept evidence from a key witness that's compromised and a judge who seems to be biased? Why are we moving forward with the case? Because you've cost us all this time because you took an ex parte meeting and then you had an ex parte meeting. And so now you've cost the taxpayers all this time and you've made law and crime rich and YouTubers got a lot of clicks and all this great stuff for everybody else. But the citizens of Georgia are suffering because you cost us time, but you don't have the decency to take the time to ensure that moving forward is the proper procedure at this point, or at least to prove that you're right. If you're so right, then prove it. Like pudding here, prove it. It's in the pudding. Let's just put it on the fact. Let's just do it. Put your money where your mouth is. Oh no, I don't have time for that. We're gonna move on.
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. I just, as a real.
Removing the cloud that's hanging over the case right now.
Yeah, I'm not going to do that.
And if
you can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll
Good job, attorney. Good job.
Removing the cloud that's hanging over the case.
Aren't you interested in removing the cloud that's hanging over the case at this time, Your Honor? Perfect sentencing. He doesn't like that. Too bad. Oh, so sad. No one cares because quite honestly, that is my whole point. When you have bad actors or you have missteps or you just make a mistake, but you don't allow the process to be impartial, the process to be complete, or to do all the steps that is necessary, you cut corners, or you just decide that you just the HB and the NIC and all the others in between because you're the judge and you wear the robe, you compromise the integrity of the case. No matter how good the case is, because now every nobody, including me, who don't know nothing about this case, as far as I'm concerned, sounds like something's going on with prosecution and judge. You leave people without the confidence that he's getting a fair trial. And the lack of that confidence says to us, oh, well, then maybe he's not guilty. Maybe you are setting him up. Maybe you are making up charges. Maybe you are lying to us that these are the facts because you're not even taking the simple steps seriously.
Right now, Your Honor,
Sir, I'd be real careful about
and he
what
doesn't
you're
like
pleading
it.
At this point in time, what you're stating to
but
the
you
court.
keep putting it on the record.
As a matter of professional responsibility.
Put it on the record.
We haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you.
You're right. We don't know the issues.
You have some professional responsibility obligations individually and to this court. And so I would.
Isn't that rich? He's saying you're an officer of the court. You have responsibilities and obligations. You have ethical obligations to the oath that you took. Hearing God knows how long ago the attorney was saying, I have an obligation to my oath. I'm ethically obligated to my client to not disclose who told me this particular information because it is a result of work product. It is a privilege. You said, oh, no, doesn't matter, not important. Now you're telling this attorney that he has ethical obligations and oath to not disparage the court and speak ill will of the process, when quite frankly, it sounds more like the truth than hyperbole.
I would just leave it at that, respectfully.
I bet you
don't want to
would.
get into an argument with you about that, but I would just tell you that tread lightly, okay, in terms
Tread
of that.
lightly.
I understand, Your Honor, and
Tread lightly.
the certificate of immediate review would be in the interest of the court.
I'm not going to do that.
I'm not going to do justice. I can't do justice. I don't have time for justice.
I'm not at this point in time going to.
Oh, it's so terrible.
Going to.
Oh, they keep going.
I believe that's an error, Your Honor.
Right. Okay, thank you, sir.
Thank you.
All right.
Oh.
My attention, Mr. Weinstein, you filed a motion to.
Oh, okay. This is just a repeat. I was going to say they did that hearing that long. The motion should not be that long. But yeah, you don't have time for justice. That's a problem. That's a problem. And there is an element to the judge's responsibility to keep the case on course in a timely fashion, but to deprive the defense of their rights for time, no, that's not a part of the process. That's abuse of power. And so I just wanted to give you just a taste of why this, what they had to fight so hard for, what was so vital to them. Oh, not this one. Let's get out of this. Oh, hopefully they'll let me out of this one. I don't want to hear nothing else from that particular hearing. It was deplorable. And that's my opinion. And I'm sticking to it. You don't like it? That's too bad for you. That's why there's everyone got one, an opinion for all. Okay. All right, law and crime. I'm giving you the thumbs up because you've been good to me. Please don't start talking for no reason. I actually had someone else that was talking about this matter, and she had no legal background, and then she started saying things that just wasn't right. I'm like, no, wait, ex parte. So truthfully, ex parte hearings do occur. It's the non-notice on the other party and the factor that the other party didn't have the opportunity to waive their right to be present. Those are the elements that are a problem for him having an ex parte hearing. Not so much that he had one, but that he didn't allow the process or didn't ensure the process was correct and precise. So this lady was talking about how it's so illegal, it's so illegal. It's like, wait, ex parte hearings happen. There are times when it's necessary. And there's times when it's like, yeah, judge, thank you, please do talk to this person and get them to understanding what the process is. But right now, according to the defense attorney, his communications were more like, if you don't, testify, you're gonna have other problems. You're gonna be in jail. You're gonna, and that messes with the integrity of the case. All right, this is a gentleman, I don't know his name, but this is the witness that they just had to have. And this is some of the testimony. We won't do too much, just a little bit, just to get a taste for how compromising people can be for a win versus doing the right thing. Okay, I'm zoomity zoom, because this might be a jury trial. We got people standing. I don't know if they're standing for the judge or the jury. It looks like they're looking at the jury box. That's what it looks like. Okay, all right, look, let's learn some decorum. I think this is the defendant, Young Thug. I don't know. I don't know what he looks like. I don't know nothing about the man. I mean what I say. I don't know him. But whoever this is, don't do this in front of the jury. Don't do this in front of the judge. Okay, so hopefully those people are not in the room watching him yawn and be bored. That's the last impression you want them to take, especially when you're in criminal court, because your charges are serious and it's important. And so this means the world to you because your life is on the line. Your liberties are on the line. So you never want to look bored.
Please be seated.
This is important.
All right, thank
So
you.
we're letting the judge in. Judge is in.
All right, members of the jury, good morning.
Jury's in. All right, good. Good morning,
we're going to continue with our current
Poor
witness.
jury.
Mr. Cole.
Jury was not there for any one of those motions. I'm sure jury doesn't even know what happened to Steele. Hopefully, I don't know if he's back per se, because the appeals court, I think, happened the day after, later on in the day after, like the afternoon, and this is the morning the day after.
You're still on the oath, okay?
You're still,
Right, sir?
oh, he's still under oath. Okay, this particular witness. So Emily D. Baker, as we know, we love her dearly. She's the bomb, right? She speaks very highly of judge in the Reed case. I can't think of the judge's name, for one particular thing, which is being informative to the jurors and to the witnesses about their oath and responsibilities. This particular cavalier statement, you're under oath, okay? You know you're still under oath, okay? And he shakes his head, that's not a record. That wasn't audible. The clerk is going to have to denote something that says nods head, but that's really not the clerk's job. So it's not on the record that he denotes, yes, I'm still under oath. And then there's like, well, what does that even mean? To me, it's not the best way, but it happens. That's not the biggest problem this judge has. So his temper is more his problem. And the microphone is hers. I have no idea what she's saying.
I'll show you what's already been admitted as State's Exhibit 164 Echo, page 2373.
So FYI, courts across the nation are way behind on tech. We'll love a lapel mic right now. Judges, instead of pay raise for the next quarter, can you guys just get lapel mics? Not that expensive. I mean, it's a cost, but it's not that big of a cost.
And it should come up on your screen.
Okay, that's better. You found the microphone.
Looking at page 2373 of 164 Echo, who is depicted in those pictures?
Do you recognize this picture? Can you identify?
All right, and I want to scroll down to page 2373 of 164 Echo. All right, and I want to.
Does he call him?
All right,
Okay,
and
so
I want to scroll down to page 2373 of 1.
I would be so mad calling him by his street name. I'd be like, call him by his government name, Mr. Smith, whatever his name.
164 Echo.
What,
do you see, similar to yesterday, the dates?
Got IDs, we got.
If you can scroll back up, Mr.
We got IP addresses on here. I don't know about this. Okay, text messages.
You see that line that says taken?
Got my back. Wait, taken. No.
To my top mobile, same place?
Yes, sir.
Oh, when it was.
What is that?
Oh, the date. Okay, the date it was taken.
Which one? This one or that one?
The one at the top.
What about it?
What is it? What is the date?
2014.
And then do you see a number next to the 2014?
Yeah, 7-31.
Okay. You say that to be July 31st, 2014.
I guess.
Objection leading. I want you to realize this is her witness. This is direct. It's not cross. This is direct. She's leading. The gentleman cannot read the date. That's important. That's important. You cannot teach him how to read the date in the middle of trial. It's important because this is, especially since this is a jury trial, because the jurors are going to make the decision is if his word is worth listening to, if he's credible. And if the gentleman does not have the education or the willingness, I don't know what his thing is, to not read the date, you don't get to teach it to him. This is not class.
All right. Now scrolling down to the text at the bottom, yes, before, if you could please read what the text says.
Who did 372? Got my back. Love him like my mama.
And then does it say who the photo is by? You can scroll over to the right. Okay. It doesn't say who took the picture.
Does it?
All right.
Does it, prosecutor, does it say anything else? No, it doesn't.
Since you've been released from custody in 2019, have you flown on a plane with Young Thug?
I was on probation.
Okay. So is the yes or no?
I can't leave the city.
Right. To your knowledge, have you been posted or tagged in any Young Thug picture since 2019?
Not to my knowledge. I don't know.
Since 2019, have you been with together in the club? Not seen him in the club, but you two all actively were together in the club.
That's such a confusing question. This gentleman has presented that the questions need to be a little more articulate and quite concise for his understanding. And you have given him a scenario of together in the club, but not seen him in the club, but together in the club. What are you talking about? Sorry, highly educated woman. I don't know who you are. However, what are you talking about? Like, that is so weird. Together in the club, but not seeing him. If you're together in the club, you should be able to see him, should you not? Not just, what she's trying to say, it's not a coincidence. It's not that you happen to arrive at two separate times. Be a little more informative, but that double talk right there is confusing. And the gentleman doesn't, so far, seem to have the capability to understand what you're talking about. And he's not supposed to. He's not supposed to have to decipher your codes.
You said since 2019?
Yes, sir.
He don't know. Just say, I don't know, poor thing. There's no answer. Objection. No answer.
Whenever you're ready to answer.
Oh, what I supposed to say? I think you
Yes
should
or
say
no?
something else.
No, I'm waiting for your answer. Yes or no?
Answer to it.
The question I just asked you.
Oh, what is your question?
Sure. Since
Poor baby.
2019, have
Okay.
you and Thug been together in the club? Now, I've seen him in the club, but you two actively were at the club together. Either y'all.
Oh my God. She's still asking this question the same way. She didn't have a better set
I've
of
seen him in
verb.
the club, but you
and
two actively were at the
adjective.
club together. Either y'all went to the club together, y'all were at the club together. Have you done that since 2019?
Thank you. Somebody object around this part.
That was Mr. Matthews Jr. Hey, Mr. Weinstein, do me a favor, push that camera on the top of the podium.
Oh, now he's the tech guy.
Push the Junior.
His name is Weinstein. Isn't every attorney?
Have you done that since 2019?
Who's objecting though? Wait.
Done that since 2019.
Okay. Oh, maybe this is Young Thug back here. I don't know who the people are, but I see attorneys and clients and some assistants, maybe like paralegals or something. There's a lot of people in this space. So, I mean, it's a RICO trial, right? So they're probably being tried together, I guess. And I think that's Young Thug and not this gentleman. And Weinstein, I don't know. But somebody said objection. I want to believe it's this guy here. The other I think he's co-counsel for Young Thug, and then Steele was the main counsel for Young Thug. I think that's who's objected, but I can't really tell.
Same question as the forum. That was Mr. Matthews Jr. Hey, Mr. Weinstein, do me a favor, push that camera on the top of the podium.
I thought you had all kinds of people, clerks and deputies,
On the top.
and now he has to push cameras.
Press down.
Press down on
Thank you,
it.
sir. Appreciate it.
Okay.
Since 2019, have you and Young Thug been together in the club? And I'm not talking about I saw him in the club, but you two have been together.
I'm so over this trial, to be honest with you. I don't like nobody. Just because of the last hearing. It's not fair. I have a bias. I have a bias.
Is it fair to say that your
At
relationship?
least I can call it. Wait, hold on.
I can't recall.
Oh, I can't recall. Okay, very good.
Is it fair to say that your relationship after you got out of prison is not the same as it was before you went to prison in 2015?
Huh?
So is him
Objection, sir.
is so we supposed to know he's in prison? And when I say we, the jurors, a lot of times the jurors won't know that the defendant is currently in prison and incarcerated for something else, because you'll have a motion to eliminate to leave that out. But I don't even think I don't know. But okay, so he's in prison
before you went to prison in 2015.
Has the relationship changed? We're finding out. Are you still connected? We're on Tinder.
Basis. So the form of the question? I said the question. You can rephrase it.
Yay, still is there. So for those who are part of Reed's, watching Reed's trial, Massachusetts versus Karen Reed, you will know that the objections that that judge is entertaining are what's called no ground objections, meaning that the attorneys are not speaking the grounds for which they object. In open court, they will go to sidebar and speak more privately with the judge, but it still gets put on the record with the court reporter. It's just not to the public or in front of the jurors. And I can see why that would be, even though, wanting to watch it and wanting to learn, you want to know and you want to be nosy. So you want to know why the judge is overruling or sustaining an objection, and why does that objection apply? I kind of agree with high profile cases that if the objection is just an objection, that without stating grounds, it has the potential to be cleaner. And I know that may not be everyone's opinion, but for me, if we go back to the Depp v. Heard trial, you would have an objection to form, but really the objection should have been argumentative. Or you would have an objection to hearsay, but it should have been an objection to form. So consequently, the objection could fly under a different ground, but because the attorney cited the wrong ground, the objection got overturned or sustained, whatever have you. This, in the Karen Reed trial, it allows the objection to be upheld or refuted, regardless of what ground, thereby giving all the potential objectionable reasons in consideration. That's the way I see it. But he said he's objecting to it being leading. She's been leading and compounding the whole time, but good.
Is your relationship the same with Young Thug?
No, it's
since
not.
You got out of prison as it was before you went to prison in 2015.
Are you in prison now? Did you go to prison in 2015? I didn't even hear foundation to him going to prison. What did he go to prison for? I'm curious now. I'm nosy. I'm like, should I trust this guy? He's in prison?
I'm trying to.
Do you have the same relationship with Young Thug since you left prison in 2019?
Criminal attorneys, criminal prosecutors. Do you just want to ask, do you have the same relationship with your witness you had yesterday that you had? Like, is today a new day? Is he answering your questions today? Didn't he tell you he wanted to plead the fifth? You should let that man alone.
As you had with him before you
He
went
don't
to
answer
prison
you
in
nothing.
2015.
No, he don't know him.
I'm confused. So help me understand. If you and her y'all got a relationship 10 years ago, so today is y'all relationship the same from 10 years ago today?
Is your relationship the same?
I need an answer.
Is your relationship the same as it was 10 years ago?
I don't think nothing would be the same from 10 years ago. I don't know how to answer that. I don't know.
Okay. Is your
Okay, I'm sorry. People's lives are on the line, and I'm so sorry, but this is hella funny to me. To me, I needed a good laugh. This is good for me because I feel you, bruh. I feel you so much. He's like, look, what you mean? Is it the same? Today ain't the same as yesterday. Why would it be the same from 10 years ago? Poor lady. She's trying to. Her braids are nice. I like her braids.
relationship better with Thug or worse or the same?
Why is he Thug? I thought he was Young Thug. Why is he not Mr. Smith? Why is he young? Why is he Thug? What kind of decorum does this court have?
I don't know what to say to that.
No.
I don't.
Ask and answer, Your Honor.
Have you, and this is yes or no?
He doesn't know.
Have you spoken with Thug in the year of 2024? Yes or no?
This year?
This year.
No.
Okay. In the year of 2023, have you spoken with Thug? Yes or no?
Yes, you
Overrule, sir.
I don't think that's leading.
In 2022,
That's
have you
giving
spoken
time.
with Thug? Yes or no?
I don't know. Too far back. He don't know what today is. Move on. Oh my God. I'm so glad I'm not in this jury box. I feel so bad for the jurors sitting through all of this right here.
I can't recall if I was in. I can't recall when did I got arrested. I don't know if it was 21 or 22. I don't, and I don't want to say yeah or no to it because I don't know if I was on the street or if I was in jail.
And quite actually, you don't have to justify why you don't know something. You don't know. You don't remember. Done. I don't remember. I don't recall. Not sure, ma'am. Don't know.
Let me ask you this: while you were in prison, did you ever speak with Thug?
No.
All right. Thank you for that. Do you know someone by the name of Marquavius Huey?
Oh, Marquavius got a name.
Someone named Quay.
I know a lot of Quays.
Okay. Do you see any of the Quays that you know in the courtroom today?
Yeah.
Okay. How many of the Quays do you know are in the courtroom today?
One.
Okay. Can you identify him by article of clothing that he is wearing?
Wait, come on, go to the court.
Where he's sitting right there, like I don't know what color it is he got on.
All right. You said over there. Is he sitting? Is it the man with the gray and cream jacket?
Leading objection. No, ma'am. No, you can't start picking out people.
It shows so reflect.
Thank you. How long have you known Quay?
Not long.
When you say not long, what does that mean to you?
I don't know Quay like that.
Okay.
It sounds like his attorney went ahead and just stipulated that the Quay that he's speaking of is in fact his client. I think that's what the gentleman said.
Have you known him for a year?
And that's why she said thank you.
More than a year?
I haven't been around him a year.
Want to just shoot ourselves at this point. Listening.
Yeah, because I know somebody. I've been in jail. I've been away, so.
I know that's right. Knowing a person, don't make you know them.
In 2023?
I met Quay probably. I only knew Quay personally. Been around him no less than 90 days. Like no longer than 90 days. I don't know. I haven't been around him personally to say I know him that well.
Let me ask you this: in 2021, did you know Quay?
Where is his attorney? I would object. She's reinventing his testimony. His testimony is sensible, even though his articulation is a little difficult. What he is stating is that his knowledge of this particular individual is lucid. They've had an encounter of knowing one another, accumulation of 90 days. Over how long of a period of time, he doesn't know because he was in jail for some time. So maybe when he got out, he knew him for 10 days, went back in, came back out, knew him for another 10 days, came back in. And whatever it is, whatever the accumulation is, his bottom line is, I've known him for 3 months over the last several years. And now here she's coming to say, did you know him in 2021? That's 4 years, or no, that's 3 years ago. So if he says yes to that, does that now mean he's known him for 3 years? When the man is saying, I've only, been around him for 90 days, 3 months. Now you're changing that to 3 years? What?
In 2021, did you know Quay?
I think that's when I met him.
That's when I met him. I met him in 2021.
Do you
So now his testimony, see that, I don't know. This is not my expertise, but I'm telling you, I would want an attorney to object to this, because now to me, this is recharacterizing his particular testimony. And I'm considering that there's some disability to his communication style. And I'm concerned that his articulation is not really up to par with her representation.
How you met Quay in 2021?
No, I don't.
Met him in 2021. Have not known him for 3 years. Only known him for 90 days.
In 2021, did you consider Quay a friend?
I
How?
consider him cool.
How? How is he a friend? You've only known him for 90 days.
I'm going to start in 2021.
They can fetch.
How often, if at all, did you see Quay?
I don't know.
I'm getting ready to say.
Would it be weekly?
I seen him when I seen him.
Okay. Would that be once a week, once a month,
That's
every couple of days?
I saw him when we had time to see each other.
And I'm asking very specific.
I can't say
how often that was.
He needs his own attorney. Where is his attorney? This is ridiculous. This man is being
when I wake up,
underrepresented.
my day is not planned. I just go with the day.
You say he don't have a diary.
I'll just ask you again.
He don't have a journal for you, Mom.
Did you see him on a weekly basis, on a monthly basis?
I saw him when I saw him.
Whenever I saw him, that's when I saw him.
Would you speak with him on the phone?
Yeah.
Was that, how often would you speak with him on the phone?
I don't know.
When we had called each other for something.
Just say,
did you speak with him on the phone more than when you actually saw him in person?
I don't know.
I spoke to him when we spoke to each other.
Did you speak to him more, or did you see him in person more?
I don't know.
What you mean?
I don't know.
What would you do? Would you see him more, or did you speak with him on the phone more?
I don't know.
Meaning?
You said you spoke with him on the phone.
I have, yeah.
Did you speak with him on the phone every day? Did you speak with him on the phone once a week? Did you speak with him on the phone once a month?
How is he supposed to answer that question? That is compound. He says yes. Now, which one of those answers is true? Daily, weekly, monthly? And he already
spoke to him when I spoke to him.
He already told you. I talked to him when I talked to him. When he answered and when I called.
You said that you all would see each other. When you would see each other, what type of things would you all do?
Mind our business. Say it. Say mind my business.
Shoot dice.
Shoot dice. Mind our business.
Go to parties. We mainly shot dice.
I want him to say mind my business.
Did you ever speak with Quay via FaceTime or some other video chat?
I don't know. 3 years ago was a long time ago. I don't know.
What you mean, some type of other video chat?
Well, let me just ask first. Did you ever speak with Quay on FaceTime?
Is somebody laughing or?
I can't recall if I have.
Blowing their nose. Oh man, this is painful. Well, anyway.
Would you give Quay advice?
What?
Would I give Quay advice?
Yes.
What kind of advice? To do what? How to roll the dice?
What that for me?
Did you advise Quay on certain people he should hang around with?
Oh.
Or not hang around with?
What about?
Have you advised Quay
on
individuals he should or should not hang around with?
This is where they're gonna get him.
I probably have.
Okay. Specifically, did you advise Quay on whether he should hang around?
That's the question.
Have you ever advised Quay on hanging around Young Thug?
Leading.
I told Quay that man, I have a personal problem with Young Thug.
Did you advise him on
you have a
whether or not he
personal
should hang
problem?
around Young Thug?
What's your personal problem?
I thought I just answered it.
Yeah, he told you.
You answered you had a personal problem with Thug. That wasn't
right,
the
and I told him that. Yeah, I advised him that.
What is the that you're referring to?
Whatever you just asked me, I agree to what you just said.
No.
So for clarity for the record,
No.
you advised Quay about hanging.
Integrity of this witness testimony is so lucid. I'm concerned as to capacity to understand. I'm concerned that he's agreeing to things just to be agreeable and not because they're factual. And the jurors are looking, if the jurors are, I don't know, hopefully the jurors are doing better than the judge when it comes to looking at the facts of the matter. But if they're looking at the facts of the matter, they're looking at this gentleman and saying, there's nothing he can tell me because I don't believe him. I don't believe that he believes what he's saying. I don't believe that he understands what he's saying. and we're up here wasting a whole bunch of time with this. That's the
Hanging around Young Thug.
What's your objection?
I'm objecting to stupid. That ain't an objection, but that's how I feel about it.
Now Young Thug.
Stupid.
What's your objection? He hasn't really.
He asked and answered. He did answer. He answered in his capacity, and that is the problem. That is the problem. His capacity is not giving you what you want, but that doesn't mean you get to make fetch happen. You don't get to all of a sudden invent the facts just because he doesn't have the capacity to give you the information that you want.
Ask him on whether or not he should hang around Young Thug.
I told him it is what it is. Like,
I just answered it.
No, you told that you answered you had a personal problem with Thug. That wasn't
right. And I told him that I advised him that.
What is the that you're referring to?
Whatever you just asked me, I agreed to what you just said.
So for clarity for the record, you've advised Quay about hanging around Young Thug.
What's your objection? He hasn't really clarified. I think she's trying to get him clarified, so I'm overruling your objection.
Shocker. He's going to overrule the objection. We're not going to be integral about what the witness is trying to put forth as a factual statement. We're going to clean up the record so that it makes sense to incriminate someone, because this gentleman is not making articulable sense. But far be it for us as the judge to ensure that the witness is not being coerced into just being agreeable and being restated and clarified to the benefit of the prosecution.
You advised him on hang around Young Thug.
I told Quay that he needed to watch who he hang around.
And was that in 2021?
I don't know when it was.
And was that regarding Young Thug, though? I told Quay he needs to watch who he hangs around. Was that regarding Young Thug? Who was that regarding? Oh, Lord, we still shuffling papers.
You met in 2021.
Come on.
Have you spoken with Quay in this year, 2024?
No.
No. Did he answer?
You said, have I talked to him this year?
Yes.
No.
What about last year in 2024?
I cut all communication with everybody, period. I haven't spoken with nobody.
We've talked about Quay, Thug, Shannon, and Gay. Do you know any of the other defendants?
No, I don't know nobody else. How many?
We spoke about 4. Do you know any of the other defendants?
No, I don't know.
Do you know someone by the name of Trontavious Even or Tick?
Who?
Tick or Slug?
Yeah.
Do you know by his given name or just Tick or Slug?
I know him by Tick.
All right. About how long have you known Tick?
For a while.
How'd you meet Tick?
Don't know.
And when you say for a while, would it be more than 5 years ago?
Yes.
Back when you first met Tick, how did you start your relationship with Tick?
I don't know. I can't reflect back on when I first met him.
Why can't you reflect on
Good job.
I know a whole lot of
He
people.
doesn't remember.
What was your
Like, yo, for real. Now, I'm giving him a little bit of a hard time, not because I'm judging him. I'm giving him a hard time because I'm concerned about his integrity and the integrity of the court because of the circumstances for which this particular information is being drugged out of him. But he said he articulated well. I cannot reflect on that. I do not know. And you're gonna say, why can't you? I don't remember. He doesn't remember, or he doesn't want to, but whatever.
Just like it would be with anybody else from that I know.
Do you get along with everybody that you know?
Yeah, we cool.
So I'm saying you're cool with Tick.
That's what I said.
What type of thing would you do with Tick?
What you mean?
Did y'all go out? Did you go shoot dice? What type of things did you do with Tick?
Things young black men do in the neighborhood.
I don't know what young black men do in the neighborhood.
Try to survive and stay away from the police.
Do you do anything else besides trying to survive?
Stay away from you.
Yeah, get locked up.
Okay. Anything else besides getting locked up?
You got my criminal history, right?
We're not talking about your criminal history, Mr. Copeland. Is there anything else that you
What do y'all do? We avoid you. That's what we do. We mind our business. I love it. I love it. I mean,
I don't recall.
he's not. I'm surprised you're not treating him like a hostile witness because he's not cooperating. I love it though. He's like, I mind my business, like you should be. All right, Weinstein. Oh wait, how many attorneys get to ask questions? All of them? Oh, this is crazy. We got 1, 2, 3, 5 defense attorneys. Okay, they're looking at evidence. Obviously, she's sharing one packet with all 5 of them. We don't have enough for the each defendant. We only got 1 evidence packet. Hold on. I don't know. Let us have a sidebar. I don't know what is going on in these streets of tomfoolery, Georgia, Massachusetts, and whatever other states. I have never not killed at least 3 trees in a case. Like, you have all of the copies for all of the defendants. You don't just have one copy. When did this become a thing? We only have one copy and 5 defendant attorneys have to huddle around and make sure that they all can see it from that one angle. I would, appeals court would hate me. I would be like, I want to reflect on the court's record that their counselor is only providing one copy and we are without proper copies of this particular evidence. We can't sufficiently review it because there's 6 of us, 12 defendants, and a million other eyes that can't see it because counselor is being disparaging and keeping evidence. I would be so rude on the record because everything's up for appeal. What happened to the sound? I mean, okay, so they obviously object to something that's being presented as evidence or trying to be presented as evidence. And hopefully the sound is just because they are. Okay, there we go. Very good.
I'm showing you what Mark did to 352 Yankee. Tell me if you're individual 352 Yankee.
What?
Yeah.
Who were the people 352 Yankee?
Me too, and Liddy.
You're on this house. Like the edit 352 Yankee is that.
Okay, so she just verified who's in the picture.
Yeah, I have an objection, Your Honor. Basis.
I have an objection. Basis. Well, I can't even get the word objection out, Your Honor.
Portions of the image being approached, and I can show that to you.
Portions of the image are altered. He tried to tell her. She's like, I don't care about that. I'm getting my evidence in. Care about your portions. It's a cute suit, though. I like her pantsuit. Oh, why am I sitting here for this? So obviously it's sidebar. Talking to the judge. How long have we been here? I don't even know how long we've been talking. We've been talking a long time, huh? Told ya. I just want you guys to get a feel for the witness. I thought, what they made him go out? Hold on. Oh, it looks like they made the witness leave so he wouldn't hear the sidebar. So he wouldn't get an information.
All right, 6352 Yankees admitted over objection.
So they're going to admit the evidence over the objection, overruled. What a shock. Or I should say, I'm not shocked because I have lost faith in this case. Never knew anything about it until the bah humbug of it all with improper. Okay, so let us see for ourselves. Let's move us out from here. Law and crime doesn't. Thank you, law and crime, but we don't need your logo. And then we'll move you down here. So that's the state exhibits number. Okay, what to do? It has 179 likes. Well, yeah, I guess I think I'm kind of with the honor on this. Didn't think I'd get there. I don't see why I don't see what is altered in this particular picture. So I don't know I don't understand the objection basically.
Mr. Copeland, you know who you are. If you can tell the jurors who is Tick and who is Little D. Mr. Copeland, who is Tick?
In the middle.
All right. And then Little D, the one with the Dallas Cowboys sweatshirt.
Leading. If this me, this Tick.
Okay.
They got no choice but to be Little D.
Earlier you talked about another Little D that you called your son. Is this the same Little D?
Do they look like the same Little D?
I'm asking you a question, Mr. Copeland. Is it the same Little D?
No.
Okay, so she's not being obnoxious as you may think she is. It's just funny because it's funny, but she has to ask those questions because the record has to reflect that you know who each person is and be clear that these people are not associated in any other way. So she's not trying to be rude to him, even though he's like, come on now, my son is not older than me.
How do you distinguish this Little D from the other Little D?
What?
They look like 2 different people.
When you are addressing or talking about them, how do you distinguish the 2 Little Ds from each other?
What you mean?
Do you call one of them Little D from Cleveland?
If you ask me which Little D I'm talking about.
And that's what I'm asking you. When you are
talking
about,
you should just ask me that.
Mr. Copeland, which Little D, how do you describe him if you're talking about him? If you're talking about the 2 Little Ds, how do you distinguish this Little D?
I just said he looked different keeping him.
Okay, thank you.
Does he have candy in his mouth?
About how old were you all when you took this picture?
Can she get away from the camera so we can see him? Go back over there.
I don't know.
Do you have hair on your head when you took this picture?
What you
When you
trying?
took the picture?
He does not like her. He don't like her at all.
It looked like I got hair on my head.
Okay. How long ago have you been bald?
He said, I ain't bald. That's for my hair. Oh, he ain't having it. He ain't talking to
I
her.
got out of prison.
So this is before you went into prison.
It's an old picture.
And that's what I need to know. Thank you very much.
He's like, you ain't welcome. He did not want to be there
How
for
long
him.
have you known Little D from Cleveland?
Huh?
How long have you known Little D from Cleveland?
No who?
How long have you known Little D from Cleveland?
Okay. I think he's doing some acting at this point. Looking at his body language gives me some better clarity that he just
I know him back in
wants to
20.
be there. Let's see, what is this?
I think I met him in 13, 2000.
Evidence coming in. Oh, who are these people?
No.
We got a whole, we got a whole, sorry. We have a whole crew of people on Zoom.
Who?
Okay. So whatever she did, she ignited another microphone that put Zoom on the main feed. And it's just like different angles of the courtroom. Very interesting. But that's the presiding judge. So I'm not sure. Okay, anyway, I thought we were gonna have some other people, but no. Looks like the courtroom.
No. Who? Yeah.
I'm going to show you what's already been admitted as 51.
Anyway, so he knows the people, whatever people she wants to know. I want to hear some of the defense to get a feel for why do we care if he knows the people. Your mic.
The defense is going to have some objections to that video, so I didn't know if I want to take it up before the comes in.
How long is the video?
There's going to be 2 videos, Your Honor, and they're only each one is 17 seconds, and one might be like 10 seconds.
All right. Can you identify them for the record? So.
Yes, Your Honor. There's going to be Stacy's exhibit 347 Yankee and 343 Yankee.
347 Yankee, and what's the other one?
343 Yankee.
All right. Let me see states. Play for me states 347 Yankee, please. All right.
Like a clerk.
Yes, please. Thank you.
She actually doesn't look like the court reporter because she's not looking around a lot. Maybe she's another clerk. I don't know.
Yeah, this is my attire for the day. You know, this is how I'm swagging on a bitch and a boyfriend. You can get it. Got my younger with me. You deal what I'm saying? Just the motherfucking bruise how we do it. Nigga. Got a white production. Yeah.
What the? Okay, hold on. Does anybody know why that matters? Put it in the comment section. Like, who the hell? Sorry, who the heck? What is this? Swagging? Okay, he's talking about his clothes. When your boyfriend beef with us, sit in that front seat. Get it or get it? Guess ain't no riddles. I don't know. Okay.
Just the motherfucking bruise how we do it. Nigga. Got a white production.
Okay. He made a video. Okay.
Was that it?
Yes, sir. That's the first one.
That's 347 Yankee. All right. Let me take it by the numbers then. Mr. Sharp, what's your objection? All right, Mr. Steele, do you have an objection, sir? Yeah. What's the basis, sir?
I would ask for the basis of the reason that's being sought to be admitted under what ground, because I'm going to object to cumulative if it's association. I'm going to object to relevance because I don't know what the relevance of saying.
I love it. Go ahead, Mr. Steele. All the claps and snaps. Like, what is this supposed to be? What is this? Because they're associated. They hung out together. He's testified to this already. It is cumulative. You have pictures of this effect. This is what. And then, yeah, relevance. I love it. Object all day. Pull all the objections together, Mr. Steele.
To cumulative if it's association. I'm going to object to relevance because I don't know what the relevance of saying this is the attire for the day. And then
I don't either.
there's commentary under the right.
It should be redacted. I would move to redact it.
Written words, which
if it's not his.
I would object to as well.
On what basis for the words?
It's a social media posting on a person's account, which this court pronounced Scarfax, and it's not Jeffrey Williams' account. He didn't write those words.
Thank you, Mr. Steele. Is Young Thug's name Jeffrey Williams? Is that his name? Thank you for introducing us to your client. I don't know what you guys can see and tell, but the court is meant to be of high decorum. And regardless of how you feel about the defendant, you speak about the defendant in a respectful manner. You don't call them something that is like my son. He has a nickname that only he wants his family to call him. It's nothing crazy. It's nothing to do with Thug, but he doesn't want his friends to call him that. He doesn't want other people to call him that. My husband, he has a nickname. I'm not running around calling everyone by that nickname. That's only for my husband. And quite frankly, I'm the only one that's allowed to call him as such. So consequently, even if this man has a public name that is different from his government name or that which is on his ID, in a court appearance, you are to respect all parties. And a part of that is calling them Mr. Williams, not Thug, not Young Thug. And if by some chance you just can't, you're just deplored and incapable of civility in court, then you refer to them as the defendant Williams. So thank you, Mr. Steele, for telling us that Jeffrey Williams is actually the gentleman who is on trial, because I had absolutely no idea. And finally, I know his name.
There are unknown people on some of them.
Exactly. That should be redacted for real, for real. Like, well, you have all those other people on there.
So is it, what's the basis for for the third base for your objection? Okay.
Which one?
For the writing.
And then for the
cumulative.
Rest of it,
I heard relevance,
yeah.
Cumulative, and hearsay. Is that it?
I would hope so.
Okay.
And then, of course, the reason I say cumulative, there's been detectives with an S who are allegedly in association here on the indictment. There's been other witnesses identifying people who are part of the indictment that allegedly are part of a crime conspiracy. There is, this witness has already said who he associates with and identified a series of pictures. There's numerous, I don't know the number, but there's numerous pictures showing associations. I just don't know when there's enough. I've objected to cumulative. I know he gave me a continuing objection, but at some point, it just seems like a waste of time in the world.
All right, thank you, sir. All right, state wish to respond. Three bases: relevance, cumulative, and hearsay.
Yes, Your Honor. As to the hearsay, Your Honor, the state has no objection with removing the information on the side.
Should have been did that.
All right, well, that's done. That's one basis. I'll sustain that that part of the objection. Okay, so
why are you saying it? Because she doesn't have an argument against it? What if she argued against it? You're looking so biased. Whether you intended to in that instance or not, making the ruling in that manner of that, of that timing, it really gives the presentation like, oh, okay, she doesn't care, then I don't care. Versus making her articulate her responses to his objections, just the way you made him do all three of his, make her do all three of hers, and then do the ruling one by one.
So what about the other two, relevance and cumulative?
As for relevance, Your Honor, again, this is direct evidence of the nature of the relationship with several individuals on this indictment. Inside of this video is Mr. Williams.
I don't know what she's saying.
Mr. Williams, Mr. Copeland, Mr. Arnold are in this video, and it shows their association together. We have pictures, but this is them. Oh, and Dolly White, who's going to be, who we've heard about as far as the Little Wayne bus shooting, and we should hear more about Ms. White as the rest of this particular act develops, Your Honor. It shows the relationship of these parties.
Did she say Little Wayne bus shooting? Is that a video shooting or a gun shooting? What is she talking
together? The defense has been that Mr. Copeland is not really a friend of Mr. Williams. He is a friend of, I believe, from opening statement, a friend of Demikion Garlington. And again,
this is why I appreciate the judge from Massachusetts versus Karen Reed. I can't think of the judge's name. This is why I appreciate her doing sidebar objections, because all this conversations, I believe, is happening in front of the jury, and it's confusing. You have asserted all kinds of allegations in a simple response to relevance of this particular evidence. I believe the jury is in the room during this time. So this, even though me as a public person want to know why, Judge, why do you feel that this should be sustained? Or, okay, I'll let him have that. I don't necessarily care for those particular commentaries. I much appreciate sustaining a rule as the judgments, but nonetheless, or do you believe that? I don't care for any of that, but I do appreciate, whereas I know Emily D. Baker also appreciates that she explains to the jury as she should. I appreciate that too, in a frequent basis, I should say. I do personally appreciate that the objections are at sidebar, because this is presidential. Sorry, I'm tired. Has the potential to be prejudicial. Oh my. Anyway, it's bad for them. Okay, it's bad. I don't like it. I don't like it in open court like this, because she's talking a whole bunch of mess.
That's a contradiction to that this is Mr.
So basically, Your Honor, this has relevancy to the contradiction of the testimony that Mr. Copeland is only associated with one defendant, and in fact, he has a very close relationship with other defendants depicted in the evidence of the video. What does that got to do with Lil Wayne's bus shooting and Dolly Parton and everything else she said?
Williams in his home, it appears, or someone's home, let me say that.
Yeah, you don't know where it was.
Shows the nature of their relationship. And so we think that it's relevant. It's not cumulative, Your Honor, because this is not new. This is not the same evidence as
no, it's not new.
This is different.
You see her catch herself? It's not cumulative because it's not new. That's what cumulative means. It's not new. We've already gotten it. We've already proven that fact. So we need not continue to prove that fact anymore. It's basically
evidence. One, it's a video. And two, that this would be analogous that if we have evidence of a murder, we can bring in different pieces of evidence. And this is a different piece of evidence. This video. We can two, but it's not cumulative, Your Honor, because this is not new. This is not the same evidence as the pictures. This is different evidence. One, it's a video. And two, that this would be analogous that if we have evidence of a murder, we can bring in different pieces of evidence. And this is a different piece of evidence. This is video evidence showing the nature of their relationship.
All right, ma'am. Anybody else have an objection?
What the F? Okay. Not cumulative. Okay, I guess she did reply to relevance because she said it's new information. It's an...
I'm going to admit States 347 Yankee over objection, Mr. Steele and Mr. Steele in particular. I'll just make a continuing objection.
And we're still continuing, and I hope I was under the belief for cumulative for all association.
No, I'm not giving you. I mean, I'm overruling the objection. I've sustained it as to hearsay, but I'm going to admit relevant. It's relevant, and I'm not going to. It's not cumulative at this point. So okay.
Well,
all right. Can I see?
So it's not cumulative because she has asserted that there's other persons within the evidence that she wants to set forth, as well as, I guess he was trying to distance himself from one of the defendants, and she's saying they have a much closer relationship than he reported on the stand. But I don't know how that could be clear at all, because I have no idea what his relationships were, other than he's cool with the people he's cool with when he's cool with them and he's not in jail. That was his representation. And that's why I didn't like her re-articulating his representation of his testimony, because she would clean it up. And that's not what he was saying. He was like, we cool when we cool. And that's whenever it is. And yeah, I met him then. I've known him for about 90 days. Like, we don't know each other. I've been in jail. I'm out when I'm out. And when I'm out, we roll dice sometimes. And we stay away from cops and prosecutors.
343 Yankee, please.
If you're a juror on this trial, what do you feel about this? Do you feel informed by this particular information? Like, what happens when you...
Fuck you, pussy. All right,
Yeah, we got a turbulent on here.
I am pool. Oh, he got it wrong. Y'all don't play dice. Y'all don't roll dice. You play pool. Is that what we're proving today?
Okay, Mr. Sharp, do you have an objection for 343
I got an objection. Cumulative and stupid.
And the basis of that, okay, the bases of that objection, sir?
Okay, can I just describe what I see first?
No.
Because I think it's important
that
we just talk about what we're seeing. I believe
that for the record?
Mr. Kendrick in the foreground right now, Mr. Copeland in the background. Mr. Copeland says F-U-P-U-S-S-Y, and it's something that I can't decipher afterwards. Then the camera pans to another gentleman who I believe may be Martinez Arnold.
Why are you testifying?
He says to my ears, we have a target on our heads. And then And he also uses what I believe to be drugs. And then it goes to
He's
other
smoking a cigarette.
individuals. I believe I saw Quindarius Zachary
Asserting all of these
present as well.
illegal things.
So I have several objections.
For
First of
sure.
all, what Mr.
Anybody?
Mr. Arnold, or the person I believe to be Mr. Arnold, says is hearsay, and it violates the Confrontation Clause. He is not on the witness stand. I do not anticipate him taking the witness stand. Him saying we have a target on our heads is a statement that violates both the Confrontation Clause and the hearsay rules. It's clearly not any sort of co-conspirator statement. Also, regarding the video and audio as a whole, I guess the state would argue that it's relevant to show association. I think that's already been established. I think that's cumulative. I think the probative value of that at this point, and the marginal probative value after all the other evidence to show association is minimal. Compare that with the prejudicial effect, which is these gentlemen being around and engaging in drug use, the
illegal in Georgia.
vanity, the different things of that nature. I think that the prejudicial effect and the unfair prejudice substantially outweighs any probative value from this video. However, Your Honor, if Your Honor were to find that it's relevant to show association, which
we can stipulate to that.
Only possible relevance, then my concerns could easily be alleviated by admitting the video and not the audio, and therefore it would cure the hearsay and Confrontation Clause concerns from the audio and what is said by a non-testifying declarant.
All right, thank you, sir.
I love it. I have no faith in the outcome of it, but I love the fact that he did present a good articulable objection relative, especially to a declarant that is not a witness. So you have what can be taken as, what did he say? We have a bounty on our head or something to that effect, can be taken against these particular defendants as saying, oh, they collectively are in some kind of grouping, and there are people that have a desire for their death. And consequently, now you can, as a prosecution, present a case that maybe they are running RICO activities, and maybe they are gang members and affiliates and associated as such. And you can take that and use the words from someone who is not a witness and is not going to testify. So it is prejudicial. It's prejudicial to the defendants, because they're not able to confront that person. And the whole purpose of a trial being open and the Constitution is that the defendants have the right to confront the accusers and the witnesses. They have the right to cross-examine them and to speak to them. So consequently, that's a good objection. Let's see what happens with the judge, though.
Okay, State.
So first, Your Honor, as to the Confrontation Clause, Your Honor, this is not a testimonial statement and made to law enforcement. So this would not be a Confrontation Clause issue, Your Honor. As noted, this is a statement by a party opponent.
How's Mr. Arnold a party opponent? Just tell me.
Because he's on the indictment, Your Honor. He is a previous co-defendant in this case. Although he's pled, he's still a party opponent.
So you're saying his statements are admission by a party opponent? Yes,
his statement.
So he's pled out. He's no longer a party opponent. He's pled guilty.
Be an admission by a party opponent. Okay. As far as what Mr. Copeland says, FU, PUSSY.
Wait. But the basis was he's not a witness, so we can't cross-examine him and ask him what he meant by his statements to clarify. Wait a minute.
Your Honor, he is a previous co-defendant in this case. Although he's pled, he's still a party opponent.
So you're saying his statements are admission by a party opponent?
Yes, his statement being admission by a party opponent.
Okay.
My criminal attorneys, does that jive? Because for me, once you've settled, because I'm more civil law, once you've settled with the party, they're no longer a part of the case. They get released. You release them. It's called a dismissal. You dismiss that party, they're done. And if you still have issue with a remaining party, then you continue the case with the remainder. But you don't keep carrying the settled party. So does that not jive in criminal law? I don't know. I'm asking. I don't know. It does not sound logical in my mind, but I don't know. So I am asking.
As far as what Mr. Copeland says, FU, PUSSY, Your Honor, the probative.
All the tomfoolery y'all got going on in Georgia, and you don't have the AJ balls. Mr. Jackson been cursing up a storm in Massachusetts, citing witness testimony. Quite honestly and truthfully, the record is to reflect what is said. So you don't get to choose not to say the word if you're trying to put something in the record. If you're going to quote it, you got to quote it. You can't say laughing out loud. If it's LOL, it's LOL.
The value or prejudicial nature of that cursing. We've omitted songs at this point that have cursing in it, so I don't know how prejudicial that particular line would be. Mr. Copeland is the current witness on the stand, so they want to cross him on his use of language. They can do that, but don't believe that in and of itself should keep this video out. As it relates to the smoking of the cigarette, we don't know what that is. It looks like a cigar, so it would be speculative to believe that it's drugs or anything else because we don't know. I didn't see in that video a bag of marijuana sitting around.
I have not agreed with this lady yet, but that one I agree. I did not like him asserting that that was drugs, but what he could have said was a reasonably minded person could assume that it is in fact marijuana or some type of illegal paraphernalia, and therefore it's disparaging and prejudicial to the clients because it's not testified to exactly what it is, unless the gentleman there can clarify what it is or what it isn't. But I agree with her. We cannot assume as a officer of the court that it's drugs. It has to be testified to.
Anywhere, so we don't know what it is. So it'd be speculative to determine if that is any type of drugs or illegal substance, Your Honor. Also, this could be an adoptive admission as to Mr. Kendrick. If it is what Mr. Arnold says, that we have a target on our backs. At no point in time did Mr. Kendrick, who is the holder of the video, deny that statement at all. An adoptive admission is admission.
So we're assuming that he heard it, understood it, and was paying attention to what the man said.
By silence, an admission by silence may be.
This is why I don't like. This is why I tell people don't be panning with me in the video. Don't just. I don't know what you're saying in your phone and what other people are saying and carrying on. And when I go and pan, I have to make sure I'm with professionals. I can't just be hanging out with just any old body because you might say something that I don't necessarily agree with, and I don't hear you at the time, so I'm not paying attention to you. I'm seeing what's next. So now this person is responsible for what somebody else said in their video. Oh my God. This is why I like criminal law. They take everything.
Kendrick, who is the holder of the video, denied that statement at all. An adoptive admission is admission by silence. An admission by silence may be created against a party who remains silent in the face, and this is of an accusation. Such admissions are proved up when the opponent establishes the following elements. At a prior time, someone made an accusation. We believe that we have a target on our back is an accusation. Then Mr. Kendrick's failure to say anything to it would be an adoptive admission to that statement. But again, we have a target on our back. It's something that a party opponent states, and that would be relevant. This video was taken in 2014, which is in and around the time of the beef that we believe the beef may have started between If Gang and YSL. And so that would be relevant information for the jurors to hear as well.
Anybody else have an objection before Mr. Sharp? Before I let you respond again, Mr. Sharp, just wait a second.
Everybody's
objection.
I just wanted to make one statement regarding Mr. Kendrick allegedly holding the camera that entire time. If you watch the video, you can see that there is a jump cut in this video.
What is it?
Jump cut. And there's a part where there's an incongruity in the video, and it's prior to the person who allegedly says there's a price on our head. If you watch it again, you can see. So,
are you saying it's spliced or it's too? Is that what a jump cut is? Or
it stopped and started again or something? You can watch it when you see it. I'm not saying the state spliced it. I'm just saying it looks at one point like the video stopped and then started again. So while it looks like Mr. Kendrick is doing a selfie video here, when you watch it play all the way through, and it's only 17 seconds, you can see it. When you watch it play all the way through, before it goes to the individual that makes the statement about the price on the head, it's not at all in evidence that Mr. Kendrick is holding the camera then.
All right.
That's a good argument. Which one might say that he had it in selfie mode and then switched it to, the other side of the camera. That's a great argument. Do we know that he has the camera the whole time? Good job, Weinstein, I think.
Right.
Your Honor.
So what's your specific objection? That being
the allegation that Mr. Kendrick has adopted that statement
exactly
because he's holding the camera and did not disavow it.
Right.
All right, sir. All right, sir. Thank you. All right.
You don't have proof to what you have asserted.
And Mr. Shard again.
Your Honor, there's not a case I can find that a person in Mr. Arnold's position would be a party opponent who is indicted.
All right, so Law Tube, you don't need to tell me nothing. Steele is getting ready to answer my question. Thank you, Steele. I knew I could trust you. I knew I could. There's not a case you can find. See, logic legal logic is just legal logic. Like when you dismiss someone, when you have settled with someone or an entity or whatever, they're no longer involved, my brother. Yes, still tell us about it.
Arnold's position would be a party opponent who is indicted. He has cut.
I'm gonna take it back just a little bit more so we can get all the full effects. Go ahead.
There's not a case I can find that a person in Mr. Arnold's position would be a party opponent who is indicted. He has cut a agreement that this court sentenced him under, and he is no longer a party here. So
he's still on the indictment, though, right?
Yeah. So
he's not a party anymore.
Any case that says the fact that a human being, an indictment is hearsay. It is the district attorney's allegations. It is total rank hearsay under Brown versus State, which we discussed earlier.
Yes, sir.
So I disagree strongly, and I just can't find it. If someone has it and I'm wrong, I want to learn, but I can't find anything that supports what the state says.
That's right. It's not there. I don't think it's there. That makes no sense.
All right, sure.
I couldn't find it either with Mr. Winfrey. If you remember him, he did not resolve his case, but he is on the indictment. I still can't. He's not here. The party, and then generally we get a 105 instruction, 24-1-105 instruction.
You may still get one at some point in time, but not
now.
now.
Oh my God.
Okay.
Okay.
All right, is there anything else?
So you may get an instruction some point in time. So because something can happen in the future, and I'm now bound to the fact that he's a party opponent, though he has been released. I think he was talking about the other guy, but it's like you deal with the facts that are before you, not the facts that are coming down the road. You got to talk about what's here, what's on the table, what's the law that supports such position.
Okay, all right. Mr. Sharp?
Good job.
I agree with Mr. Steele, but with Winfrey, but this is one step further because he's not a party opponent. Yes, it's a little absurd to say he's a party opponent to the state right now. He signed a plea deal with the state to testify. He signed declarations written by the state. He's not a party opponent, but more importantly, while he is on the indictment is no longer pending against him. He has resolved the case.
But I don't think that makes a difference as to whether or not. I mean, you can still be on indictment. You can resolve your case, and
I don't see that.
And conversation still could be
based on what, Your Honor. Let's have recess and go pull the court case or the code that supports this ruling, because we have a defendant counsel who says they can't find any such case that supports that just because you're indicted and you have now pled guilty and resolved your case that you in fact are still a party opponent. I mean, so what? You're forever with this case? What if this case is a mistrial? Now, so tell me this, guys and gals, if this case becomes a mistrial for all defendants left, does that mean that the one who pled guilty is no longer bound by their plea agreement and they in fact get to be exonerated of their charge? I would argue not. I would argue not, because you're not a part of the case anymore. So the mistrial doesn't belong to you, it belongs to those who are part of the case, who are actually parties, not former parties, not released parties. And you have instances, and now I'm going to civil thought process because, like I said, that's where most of my training is in. But you have instances where some entities are incorrectly named because you think that's the parent company of Carl's Jr., because Carl's Jr.'s parent company has a whole different name, and Carl's Jr. is the DBA. You're suing Carl's Jr. plus his parent company, but quite in fact, you've chosen the wrong company. So that company gets released. The case is still going. The company's no longer a part. They're released. You get it. It's actually a different parent company, and you find out who the true parent company is, or you misspell someone's name. And so then you don't change the name on the complaint sheet, but you change it within the party definition as to which party is actually named because the name was misspelled, or it didn't have the true last name of the person because it didn't have their maiden name, it had their married name, or it didn't have their hyphen name, or whatever have you, but it doesn't really reflect what's on their ID. So consequently, you have to change that. So if there's someone else that has that name, they're not a party anymore, or at all, even, because they were, miscorrectly assigned or identified, improperly noticed, they improperly added, they get removed. So how is this not the same case with the criminal matter? You're a party until you're released. You're released for different reasons. You're released because you're the wrong person that was indicted, or you're released because you have a plea deal, or you're released because the case is deciding not to go to court, or you're released because the case is now a mistrial or whatever. I don't understand. Or not guilty verdict,
I mean, you can still be on indictment. You can resolve your case, and
can you though? Can you really?
And conversation still could be
really
theoretically admissible.
Theoretically, we're in theory now. God forbid we stay in the law, and then that's another thing. Judge, Your Honor, you're a trial court judge. So that means you follow the law that's already gone through the theory and it's already been case law and already put into law. You don't create law. The Supreme Court creates law. You don't create law.
That you can resolve your case and conversation still could be, theoretically admissible.
Where are we pulling this
as
from?
to others. So, but I'll hear from the state, but that's not my understanding, Mr. Short.
You just made their argument for them.
Time runs out in the fourth quarter. The other team's no longer your opponent. He does not have a pending case. There's nothing going on.
While that may be true.
You gotta love common sense. Common sense and the law are not that far apart.
He does not have a pending case. There's nothing going on.
While that may be true.
And there's no.
While that may be true, but I still think the statement can be used for other purposes.
Can I just respond to the
adoption? Oh my Lord.
We have a target on our heads is not an accusation.
It's
okay. That's
so
not something
disparaging.
That would clearly elicit the response of Mr. Kendrick.
Right.
To say, oh well, hold on, you're saying something about me, so let me clear that up. That's what
that doesn't happen in real life.
You say something about me, and then I have to clear it up, or it's assumed that I agree with you.
Can you imagine?
That's not even close to what adoptive admissions are.
Good job.
Thank you.
Good job. Sound argument.
Additional, Your Honor, this also be considered a co-conspirator statement as a part of the larger conspiracy of the gang of YSL. Again, this is in November of 2014, where we believe the beef between YSL and If gang is beginning to arise and heat up. And so the fact that he says we have a target on our back, we will argue is YSL and the
how are you going to argue that if he's not there?
And therefore, this statement could come in to show the larger conspiracy, which will be the gang conspiracy as well.
Exactly.
A statement, a co-conspirator statement, it would have to be in furtherance of the conspiracy. There's nothing about that statement that would indicate at all that is furthering any conspiracy.
But that's a jury question.
No. How about this? She just proved that the reason why they want the statement to come out in evidence so badly is because it establishes that we and identifies we to be a gang. How about we can be me and the guy next to me? Why is we all 12 people in the room? We just means more than one. It actually just means another person and myself. It doesn't necessarily mean every last one of us. He didn't say the boys at YSL gang, we are XYZ. And so if he's not coming in to testify to legitimacy and the accuracy of his statement and what he meant by it, then it's most definitely prejudicial to the defendant. I'm alarmed, but I'm not a defense attorney. I don't deal with criminal laws. And so I don't know, but I just by common sense law, this is my new thing. I really agree to this. Common sense and the law are not that far apart because the law is set up to be the law of the land. It is meant to be law most agreed upon by the majority, what is in the best interest of the majority and agreed upon by the majority. Consequently, a set of common sense should follow a line with, good law of the land. And I don't find it to be good to bring in such a statement that definitely will be disparaging, that definitely will give a presentation because this is going to be their argument that they are the gang and these two little letters we mean all 12, 15 people in the room. And if they are high, they didn't hear what he did say. It's just, and he's not going to testify. I would have to argue we got to bring him in to testify then. If we're going to bring in this evidence, then the person's statement that you want to rely your evidence on needs to testify to what that statement is, what it means, and who it applies to, and why you think it matters.
Well, remember what I told you earlier during the trial of this proceeding. At this point in time, there is evidence that's been presented by the state to show that there potentially may be a conspiracy. So as a result, that's kind of the entry. So I believe at this point in time that may fall into the category of whether or not a conspiracy has been shown. Now, whether or not the jury believes that, buys it, they've proven it, prove it beyond a reasonable doubt to a jury satisfaction will be determined later. And whether or not that particular statement was made in furtherance of the conspiracy. Are you and Ms. Knight or your audio team sure that you can cut it off?
Oh, they're going to cut it off. Okay, so they won something.
Have you tested it already?
Oh, no, this is some other evidence they're trying to get in.
Tilton, whenever you are ready, man, you may resume your examination.
Thank you, Your Honor. Your Honor, permission to sit briefly for this portion of it. Now, Mr. Copeland, when we left off, I asked you about FaceTiming with Doug. I'm now going to play from your June 10th, 2015 interview, began at 10:35:51 to 10:35:53.
2 seconds, 51 to 53. Oh my gosh. I'm like the judge. You sure you're gonna be able to cut that off? Just cut it off before you came to court. And had a short version ready. Oh, hello. Can we move along? What year?
Do you hear yourself when you said you FaceTime Thug?
Say it again.
No, I didn't. Nobody heard that.
Do you hear yourself? Do you hear yourself when you said you FaceTime
No,
Thug?
I don't.
Say
No,
it again.
Did you hear when you said you FaceTime Thug?
no, I didn't hear that.
I heard I say something. I can't recall what I said. I have a hearing problem.
Me too. I got a hearing problem too.
I'm now going to play on that same date, 3:47:40 to 3:47:41. 48:05 to 3:48:06.
Did she do 3:47:40? Hold on. Let's see what that one was. This is a hard thing to do though. Dealing with text is a pain in the butt. Report. Is it Agriculture before?
Say it again.
Yeah.
I heard I say something.
47:40 to 3:47:41.
These clips are 2 seconds long, 1 second long. I mean,
And what I supposed to listen to it?
Yes.
it make you think about that Massachusetts Karen Reed trial, right? With them 22 seconds, 22-second phone calls. You can say a lot in 22 seconds. They got 1 second clips right here. 2 second clips. Any day now, I guess. Because I'm supposed to hear something. Why is he wearing a, well, I guess he wanted to, but why not put him in a suit? Court attire matters. How you're seen and judged matters. But I mean, it's to the benefit of the prosecution to make him look unkept and untogether. I just, if he were my client, I'd tell him to put on a suit. Of court. What now?
Do you hear when you said you called FaceTime on Thug? You called Thug on FaceTime for Kel.
Your ear better than mine.
He's saying, no, I don't hear it. I called him.
And the next we'll play June 10th, 2015, 3:48:05 to 3:48:06.
So the truth is, he doesn't have to agree. He does have to be honest, but don't guess, don't speculate that that's what you said. If you don't remember and you can't really understand all the words, then I don't agree. And then it'll be up to the jury to decide if that's what he said or not, if it's, what they hear. And he can clarify and say, I don't think that's what I said. I said I called him. He could say that if that's what he thinks, or he could just say, I don't know, which is basically what he's saying. And all of that works. Just don't lie on the stand. Okay, I'm so over this case. I want to get.
Did you hear you say Thug FaceTime me back?
I thought you said where we at. I didn't hear that. But the problem is there's leading. She is testifying to what is being said. And she's doing it in a good way. She said, did you hear you say FaceTime me back, or whatever the words were, versus asking, what did you say in that clip? So she gets the evidence in because she articulates it. Him refusing to accept or deny does not faze her, because no one's making her do direct without leading. So she gets to say what she wants to say. Because literally the last one, I thought he said something like, or the first one, I called him back or something about calling back, but I guess she said he FaceTimed me back. I didn't hear all that personally, but maybe that is what he said. I don't know what he said. Doesn't matter to me.
Yes, ma'am.
If he said one thing or another, I don't care, but the jury does, he does, and the defendants do. So accuracy is important for them. Okay, we what now?
Through 1
Oh, what?
43.
All right.
And FaceTime them right in your face and let you hear these niggas talk. Because they think the FaceTime can't be monitored, which is stupid. Every last one of these niggas talk on FaceTime.
And I'm going to conclude that at 1:25:45. Do you hear yourself when you say?
Objection. Thank you. Somebody object to this.
Excuse me.
I'll sustain the objection.
Yeah, you've been leading all day, girl. You've been testifying and leading.
Huh?
What is the reason why FaceTime is used?
What you mean?
Overruled, sir. You can
No.
have a continued objection. You can answer the question, sir.
Oh my gosh. Oh my gosh. Oh my gosh. I think that's steal. And I believe he is objecting to her requiring him to speculate as to what FaceTime is used for. First of all, that's not even a clear question. But who uses it? You know, when? What are you talking about? And she's trying to get in what his potential statements were at this looks like interrogation room or witness room of sorts. And the judge is like, okay, you have a standing objection, overruled. It's as if any objection still is being dismissed. And there is such an appealable presence to the fact that that is a clean objection. In my opinion, I think that's a clean objection, that this calls for speculative information he doesn't know. You can't expect him to know. You didn't ask him if he knew. You didn't say to him, do you know what the purpose of FaceTime is? There's no foundation on that. You're just now trying to impeach him on if he uses it or not. And that statement there was about people think FaceTime is secretive when it's not. That doesn't mean he uses it. Objection, man.
Overruled, gentlemen. Mr. Sharp, Mr. Steele.
Oh. So I'm done. I can't take no more of this to be case because to me, it looks like a monkey show. That's how I feel about it. I no longer care about being respectful to this court because I feel like the court is being disrespectful to its community by putting on this show. Specifically in that particular instance, 3 minutes prior, they objected to her trying to restate the evidence and said objection to leading. He sustained such objection. So now because she can't get around that and because baby girl needs help, he now, the judge all of a sudden now is like, okay, overruled. Why is the objection sustainable 2 questions ago? But now that she can't get around that objection, now all of a sudden it's overruled because she doesn't have the ability to not ask a leading question. And that's the way I see his participation as the judge in this matter. Just as little, I have not, everything I showed you right now is everything I've seen. Maybe I've seen a couple of clips more relative to when they were coming in on the motion, I mean, for the contempt charge that they were giving Steele. I had some little bit more information on that. Aside from that, I haven't seen anything of the show, not one single thing. This is all I've seen. And all parts of this gives me no confidence in the judge's ability to be impartial. His rulings are not, they're not equal. His rulings are not consistent. Just as I said in the last clip, 3 minutes, 3 questions before, those objections were sustained. And because the young lady in the prosecution is unable to restate her question in a more proper manner for direct, now it's overruled. So now she can go back to leading because her questions are she's only prevailing when she's doing leading questions. That's a problem for me. And that was another problem when they did the objections, when Steele had to list his objections. He had to list all of his objections, his reasons why, give his arguments, also the same. And then she got up there and she went to speak to one and said, okay, well, I will, what was it, the hearsay? Okay, we can redact that for hearsay. We can agree to that. Okay, great, then I'll sustain it. To me, that just gives a very poor representation by the court that they're siding with the prosecution because it is the prosecution. not because the law is on the side of the prosecution. That's a problem. So the presentation does not look well for me, and I'm over it. I feel bad for the citizens of Georgia, and I feel bad for the defendants that they have to be in a trial in such a way that this is going on, that as I see it, because the beauty of having an impartial judge and having a jury of your peers is to know that the decision that has been the ultimate outcome is in the best interest of all involved, the defendant and the community, if in fact you are found guilty. And I think all of that comes into question when you have people acting improperly and giving rise to objectable and appealable actions that can, turn this into mush and lose something very important because you want to cut corners or you're not well versed in the field. This is why I would not be doing criminal law, because it's not my thing, right? So I can't be running around trying to be a criminal lawyer or being a judge for criminal cases. I don't have experience with that. I'd be sitting there going, whatever you say. But I still maintain that the law is not too far from common sense. And I do not understand this assertion that a defendant is still a part of, or someone who's pled guilty, who's pled out. Like that's the whole thing. I've pled out of the case. Everyone says I plead out of the case. They have pled out of the case. They're out of the case. How are they still a party opponent? How are they a party of any kind? And quite frankly, if they've pled and now they're your witness, if they are anything, they're on your side. They're not an opponent. So I don't know. But anyway, I'm Lyric Armstrong, your real estate agent and advocate. Okay, Glory. Real estate agent and advocate. And I hope we learned a little thing or two. One major thing that you should have learned is to have your own attorney represent you. Do not try to represent yourself, even if you are a licensed attorney. It is to the best benefit of you to have quality representation that is objective and is not you personally, because it will be hard for you to be objective in those circumstances. I do wish Georgia better, and I hope things turn out well for all those in consideration, and that the truth does come of this case. I am not covering it. I hope that I don't have to look at it again. Hopefully the judge will do nothing else nefarious and nothing else warranting us jumping back on, and we can get to regular business as usual. Yeah, right. All right, Lyric Armstrong, your real estate agent and advocate. On to the next video.